Good morning. We are ready to begin with the first day of the hearing for formal complaint 103. My name is Betty Rankin Widgeon. I have been appointed by the Michigan Supreme Court to hear this matter. And I want to start, we've already asked if there were any preliminary matters. I don't think that there are any preliminary matters that need to be put on the record, but I will ask counsel to introduce yourself. First from disciplinary counsel, please.
Good morning, Your Honor. My name is Laura Weingarten. I am one of two disciplinary counsels.
And I am Lynn Helland, and I am the other disciplinary counsel.
Thank you.
Good morning, Your Honor. Michael Ashcraft, and I represent Judge Tracy Green.
All right, thank you.
Good morning, Your Honor. My name is Tracy Green.
Thank you, Judge. And Ms. Jorgensen, good morning to you.
Good morning, Judge.
All right, thank you. I will ask you, counsel, is there anyone else in the room with you, starting with Ms. Weingarten?
No one is in the room with me.
All right, thank you. And Mr. Helland?
Nobody is with me.
Thank you. Mr. Ashcraft, please.
Yes, Your Honor. Judge Green is in the same room as I.
All right, and we've worked out the sound so that you both are able to hear. And at this point, we don't hear any reverberations. Thank you. All right, being that there are no preliminary matters that we need to put on the record at this time, are you ready to give your opening statements?
I am.
All right, we will proceed with you, Ms. Weingarten, please.
Good morning, Your Honor. Respondent has a son named Gary. In 2015, a Wayne County Circuit judge awarded custody of his two sons, Gary Jr. and Russell, to Gary Sr. instead of to their mother. The boys lived with Gary Sr. from 2015 until June 24th of 2018 and had very minimal contact with their mother during that time. Meanwhile, they saw the respondent, who is their grandmother, at least once a week. Gary Sr. and his wife, Katie, and their children, including Gary Jr. and Russell, lived in a home in Detroit. On June 24th of 2018, a neighbor heard sustained screaming in Gary's home. She suspected child abuse and she called the police. The police came and did a quick investigation and left the scene. About 5 hours later, Protective Services went out to the home and flagged down the police, and both the police and Protective Services went into the home. Protective Services had had contact with the family prior to that date. Child Protective Services made the decision to remove the children from Gary Sr.'s home on that day. The respondent came to the home and offered to take custody of Gary Jr. and Russell. The boys told a police officer and a CPS worker that they didn't want to go with respondent and provided their reason. As a result, Protective Services placed the boys with respondent's husband's cousin, who was not related to them. In 2019, following a trial in the juvenile court, a judge terminated Gary Sr.'s parental rights to all 5 of his children. Also in 2019, Gary Sr. was convicted in the criminal court of 2 counts of child abuse in the 2nd degree against respondent's 2 grandsons, Gary Jr. and Russell. That is the backstory to what brings us to this hearing. Respondent is charged with 2 counts in the complaint. The first accuses her of covering up evidence that her son abused Gary Jr. and Russell. The second accuses her of making false statements about her knowledge that her son was abusing the boys. Gary Jr. is now 13 years old. He will testify that on multiple occasions, the respondent put makeup on facial injuries she knew had been inflicted on him by her son. Russell is now 11 years old. He will testify that on one occasion, respondent put makeup on a facial injury she knew had been inflicted on him by her son. The respondent was asked about whether she used makeup to cover up abuse on multiple occasions, and her story has changed over time. She was asked during her testimony in juvenile court in 2019. She was asked by a Fox 2 News reporter in 2019. She was asked by the Judicial Tenure Commission twice, once in her answer to request for comment in November of 2019, and once in her answer to the 28-day letter in May of 2020. And she addressed the issue in her answer to the complaint filed in December of 2020. I urge Your Honor to pay particular attention to how her story about using makeup to cover her son's abuse has changed. The truth is always the same. Lies change. Respondents' changing stories show she has not been truthful about applying makeup to her grandson's faces. Respondent was a lawyer, not yet a judge, when she concealed evidence that her sons had abused her grandsons. Her cover-up violated Michigan Court Rule 9.104(1) and Michigan Rule of Professional Misconduct 8.4c by prejudicing the proper administration of justice. Her conduct also violated Michigan Court Rule 9.104(2) by exposing the legal profession to obloquy, contempt, censure, or reproach. Her conduct violated Michigan Court Rule 9.104(3) by acting contrary to justice, ethics, honest, and good morals. She also violated the criminal law, Michigan Compiled Law 750.483A(5)(a), which prohibits tampering with evidence. She violated MCL 750.505 for being an accessory after the fact to child abuse. And she violated Michigan Court Rule 9.104(5) by violating a criminal law. And finally, she violated Michigan Rule of Professional Misconduct 8.4b by breaking the criminal law in a way that reflects adversely on her honesty, trustworthiness, and fitness as a lawyer. Count 2 charges respondent with making false statements about her knowledge of Gary Sr.'s abuse of Gary Jr. and Russell. Between 2015, May, and June of 2018, the respondent was well aware that Gary Sr. was a physically abusive person. She knew he was abusive to at least one of his ex-wives and had been told that he choked Katie, now another ex-wife. Respondent admitted during her juvenile court testimony that she knew that her son was a very stern or strong disciplinarian. Respondent knew that Gary Sr. had custody of Russell and Gary Jr. under a court order prohibiting him from using corporal punishment on his children. This order was imposed by the circuit judge who presided over the child custody trial between Gary Sr. and the boy's mother in 2015. Respondent was aware that despite the court order, her son used corporal punishment on Gary Jr. and Russell. At a minimum, she was told by her grandchildren that her son had spanked them, which was a violation of the court order. And she never asked for more information about what spanking meant. Gary Jr. and Russell told the respondent their concern about what would happen to them physically if their father learned they had misbehaved at her home. Russell showed bruises on his body and told her his dad inflicted them. One time he had an injury under his eye that he told the respondent had been inflicted by his dad. When Russell was around 8 years old, he told the respondent who was visiting that he was about to be spanked by his father. The respondent, who was aware of the court order that forbade corporal punishment, left the home as the spanking was about to take place. When Gary Jr. was 9 or 10 years old, he told respondent multiple times that he was being hit by his father. In fact, in 2016 or 2017, respondent was aware that Gary Sr. violated the court order by hitting Gary Jr. on his face and chest. She was nearby in the home and heard Gary Jr. screaming. Respondent was aware and admits she was aware that her son slapped Gary Jr.'s face hard enough to leave a handprint. Respondent saw other marks on Gary Jr.'s face on other occasions, and Gary Jr. told her that the marks had been inflicted by his father. The respondent put makeup on Gary Jr.'s facial injuries 4 times and on Russell's facial injury 1 time. She did this to try to hide the injuries. That is what the boys will testify to. Respondent's story is very different. The respondent testified in juvenile court in March of 2019. At that time, she denied she had put makeup on Gary Jr.'s bruises because she said she saw no bruises. She did nothing to communicate that she had, in fact, put makeup on injuries other than bruises. And she went so far as to say that if Gary Jr. testified that she put makeup on his bruises, he had lied. The respondent was interviewed by a Fox 2 News reporter on video, which you will see. During the interview, she denied that she put makeup on any bruises to conceal any abuse. She was quite emphatic. She said, "That is utterly preposterous. It just didn't happen." What she did not tell the Fox 2 News reporter was just as important as what she did tell him. She did not tell the reporter that she put makeup on Gary Jr. one time to prevent teasing by Russell. In her testimony in the juvenile court and her statements to the Fox 2 News reporter are contradicted by her statements made to the Judicial Tenure Commission. The respondent first told the Judicial Tenure Commission that none of her children ever told her they had been abused. None of her grandchildren had ever told her they had been abused by Gary Sr. And she remained unaware of any alleged abuse by him. She claimed she never saw any signs that Gary Jr. or Russell were spanked by their dad and denied seeing any abuse. She further claimed that she was unaware that her son administered corporal punishment to her grandsons. But she contradicts that claim by admitting to having been told by Gary Jr. that his father had slapped him across the face, and by admitting she saw the handprint on Gary Jr.'s face. She also admits the boys told her they had been spanked in the past by their father. Respondent admitted to the JTC that she put makeup on a handprint on Gary Jr.'s face that she knew had been inflicted by his father. She then offered a false explanation about why she did this. She claimed she had done so because Russell was teasing Gary Jr. about having the handprint on his face. To the contrary, Russell and Gary will both testify that Russell did not tease Gary Jr. about having the mark on his face, and that neither of the boys told respondent that Russell was teasing Gary Jr. Respondent claims she put makeup on Gary Jr.'s face once. Gary will testify she did so multiple times. Respondent denies ever putting makeup on Russell's face. Russell will testify that she did so one time. Then, in her answer to the complaint, respondent claims for the first time to anyone that she told Child Protective Services that she put makeup on the handprint. The truth stays the same. Lies change. Respondent's story has changed repeatedly. Her false and misleading statements about covering up the handprint to the commission and others are in violation of Michigan Court Rule 9.202B, which prohibits false or misleading statements to the commission. Her false and misleading statements are in violation of MCR 9.104(2), which prohibits conduct that exposes the legal profession or the courts to obloquy, contempt, censure, or reproach. And Michigan Court Rule 9.1043, which prohibits conduct that is contrary to justice, ethics, honesty, and good morals. Her false and misleading statements are in violation of the Michigan Code of Judicial Conduct, Canon 2A, which requires a judge to avoid all impropriety and appearances of impropriety. And Michigan Code of Judicial Conduct 2B, which requires that a judge act in a way that promotes confidence in the integrity of the judiciary. Finally, her false and misleading statements are in violation of Michigan Rule of Professional Misconduct 8.4B, which prohibits a lawyer from conduct involving dishonesty, deceit, or misrepresentation, where such conduct reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer. The first piece of evidence I will introduce today is a stipulation. Then police officer Melissa Adams will testify. She responded to Gary Sr.'s home on June 24, 2018. The CPS worker Leslie Apple will also testify today. Ms. Apple is represented by the Attorney General's office to ensure that her testimony complies with the very strict disclosure rules of the Child Protection Law. We will also present testimony from Michael L. Elric, a former Fox 2 News reporter who did a story on this case and interviewed the respondent on video. He will testify about the circumstances surrounding the interview. We will play a 6-second clip of the respondent speaking to the reporter. The reporter will also testify about what the respondent did not tell him. On June 14th, I expect Gary Jr. and Russell to testify. We will then decide whether to call any other witnesses. Thank you.
Thank you, Ms. Weingarten. And I will ask at this time, Mr. Ashcraft, are you planning to give an opening statement now, or are you going to reserve?
Yes, Your Honor. I'm going to make a brief opening statement now.
All right, before you do start, let me just mention, we will be taking frequent breaks today. So if I happen not to call a break at the time that someone needs to, just let me know and we can take that break then. Mr. Ashcraft, if you're ready, proceed.
Thank you, Your Honor. Good morning.
Good morning.
Your Honor, we're here today as a result of unfortunate circumstances related to the physical abuse of young children. Judge Green's son, Gary Davis Head, was convicted of physical child abuse of his minor sons, Judge Green's grandsons, in 2019. Disciplinary counsel have made 2 allegations against Judge Green. One, that she knew about and covered up evidence of child abuse. And 2, that she made false statements about her knowledge of the child abuse. Neither allegation is true. They are based upon statements made by Judge Green's grandsons, Gary Davis Head Jr. and Russell Davis Head. The boys are now 13 and 11 years of age, respectively. The boys have lived in less than stable family environments. In 2015, when they were 7 and 5, their mother, Corey Bressler, lost custody of the boys. She subsequently abandoned her sons and never exercised her parenting rights. They then lived with their father, stepmother, and step-siblings until June of 2018, when they were removed from their home by Child Protective Services due to reports of physical abuse. Not until that time did the boys ever allege that their grandmother, Judge Green, was aware of the extent of the corporal punishment they received from their father. Bressler eventually regained custody of the boys. It was then that Corey Bressler, who blamed Judge Green for orchestrating her loss of custody of her sons in 2015, mounted a campaign to destroy the character and reputation of Judge Green. She made untruthful and defamatory allegations about Judge Green and pressured and intimidated her sons to do the same. And they did so. They did not make those allegations until after they began living with their mother, Corey Bressler. In May 2019, Corey Bressler presented her boys to M.L. Elric, a former investigative reporter with Fox 2 News, for an interview. The boys were 11 and 9 at that time. During that interview, the boys stated that Judge Green knew about the physical abuse they suffered at the hand of their father, used makeup to cover up bruises, and did nothing to stop it. These were falsehoods by impressionable boys beholden to their mother. Judge Green agreed to be interviewed in May of 2019 by Mr. Elric at Fox 2. During that interview, she stated, quote, "I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous. It just didn't happen," close quote. In her response to the requests for comment and 28-day letter filed by the Judicial Tenure Commission, Judge Green responded to the falsehoods told by her grandsons. She was asked why she did not inquire into the details of abuse about which her grandsons had allegedly informed her. You will see that Judge Green stated that she was never, under any circumstances or in any respect, aware of or told by anyone the details of alleged abuse of her grandsons at the hand of their father. And she acknowledged that once in the past, the oldest of her two grandsons, Gary Jr., told her that he had been slapped in the face by his father. Judge Green saw what looked like a handprint on his cheek at that time. The boys confirmed that Gary Jr. had been slapped by their father. After being made aware of the slapping incident, seeing what looked like a handprint on the face of Gary Jr., and considering it totally inappropriate and unacceptable, she immediately contacted her son and scolded him for the act. She was satisfied at that time that the issue had been addressed as improper and would never be repeated. She was never made aware of any subsequent corporal punishment. She did not consider that single incident of a slap in the face as something that should be reported to law enforcement or CPS as child abuse. Judge Green also explained that on that occasion, because Gary Jr. expressed concern about being teased by his brother about being slapped, she offered to put makeup on the handprint on Gary Jr.'s cheek. This act of applying makeup to the cheek of her grandson and her statement during the Elric interview led to the filing of the complaint in this matter. The evidence will show you that the two charges against Judge Green lack both factual and legal bases. You will see, Your Honor, that while not appropriate, a single slap on the cheek by a parent does not amount to child abuse. And by definition, applying makeup to a handprint left by that slap does not amount to the covering up of child abuse. Corporal punishment is not a crime. Of course, child abuse is. However, Judge Green was aware only that in the past, her grandsons had received spankings with a belt and a slap on the face, leaving a handprint. She was never aware of any bruising, child abuse, or allegations of child abuse until after her son was charged with those crimes. The evidence will demonstrate that Judge Green neither knew about nor covered up evidence of child abuse. The statement Judge Green made during the Elric interview and her responses to the requests for comment are not inconsistent. You will see that Judge Green explained that she did not put makeup on any bruises to conceal any abuse, but did apply makeup to the cheek of one of her grandsons to cover a handprint left by a slap to the face. A bruise and a handprint left by a slap are not the same. The evidence will show that the statements made by Judge Green were not false in any respect. All are consistent and have never changed. Only 3 people involved in this matter have actual personal knowledge of what occurred. 13-year-old Gary Jr., 11-year-old Russell, and Judge Green. The testimony of 13-year-old Gary Jr. and 11-year-old Russell will show that those boys have changed their stories multiple times. They will be impeached with their prior inconsistent statements and evidence of deceit. We will demonstrate during this case that the testimony of Judge Green's grandsons is not credible. Judge Green has 5 children and 7 grandchildren. Each is precious to her. She has been a member of the State Bar of Michigan since 1997, having worked principally in the areas of family law and child welfare before taking the bench in January 2019. You will hear from several witnesses across a broad spectrum who will testify that Judge Green maintains an outstanding reputation and is honest above reproach. When Your Honor has heard all of the proofs, respectfully, you will conclude that the allegations being prosecuted by disciplinary counsel lack both factual and legal bases. I would respectfully ask that Your Honor maintain an open mind until the proofs are all in, And we've had an opportunity to cross-examine Gary Jr. and Russell and put in our proofs during the course of this proceeding. Thank you.
Thank you, Mr. Ashcraft. All right, at this time, we are just about ready to hear from the first witness, and I see that I think it's Ms. Adams, Officer Adams is in the waiting room. Before we get started with that testimony, would anyone need to or want to take a break at this time before we get started? All right, let's take, it is 11 o'clock. Let's be back by 10 after 11. And what I'm going to do is just take the break now. And as soon as we come back, I will let Officer Adams in from the waiting room. Thank you. Please mute your microphones. And if you want to take your video off, you may do that at this time. I think we are ready to begin. It looks as if everyone is back. All right. Ms. Weingarten, are you ready for me to let your witness in from the waiting room?
Yes.
All right. Good morning.
Good morning, ma'am.
All right. And you are Officer Melissa Adams.
Yes, ma'am.
All right. At this time, we're going to start with me swearing you in. My name is Betty Widgeon. I am the master for this particular matter. One moment. Please raise your right hand. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
Yes, ma'am.
All right. And state your name, please.
Officer Melissa Adams.
All right. Thank you, officer. There are two other orders that are in effect with respect to this hearing, and one is the sequestration order. The other one is the order regarding hearing and witness protocol. Did you receive a copy of these orders?
Yes, ma'am.
All right, I'm going to read the pertinent parts of them at this time and then ask you to swear or affirm that you have abided by these orders and that you will continue to until the end of the trial or until you are released from these orders. The sequestration order will remain in effect until the witnesses are released from it by the master or until proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies unless the witness is released by the master. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from doing any of the following: A, discussing her testimony in any format or by any means with another witness; B, viewing the proceedings on any device; C, listening to the proceedings on any device; or D, accessing or viewing any information about the proceeding via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to discovery of the failure or violation. Do you have any questions regarding the sequestration order, officer?
No, ma'am.
All right, I'm going to go to the pertinent parts of the hearing and witness protocol order. Counsel shall ensure that all witnesses have hard copies of the exhibits required for their testimony. Do you have a hard copy of any exhibits that are required for your testimony, officer?
I do have my report, ma'am.
Thank you. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room where you're testifying?
Yes, ma'am.
No witness shall access or review any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. If a witness needs to refer to a document, she may do so only if invited to by counsel or approved by the master. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you swear or affirm or certify under oath that no one has given you information by any means to assist in testifying that the counsel and the master cannot observe?
Yes, ma'am.
And finally, witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during their examination, other than the device they will use for their virtual testimony. Do you have any questions regarding the hearing and witness protocol?
No, ma'am.
All right, at this time, then, do you swear or affirm that you have abided by these orders and that you will continue to do so unless and until you are released from this order by the master?
I swear.
All right, thank you. What device are you using to testify from? Is that a cell phone or what?
It is my iPad.
All right, thank you. I don't have any other things with respect to the oath, so I am ready at this time. Counsel, are you ready to begin the direct examination, Ms. Weingarten?
I am.
All right, you may proceed.
Good morning, Officer Adams.
Good morning, ma'am.
Tell the judge your whole name.
My first name is Melissa. Last name is Adams.
How are you employed?
I am a police officer for the city of Detroit.
For how long have you been a police officer?
13 years.
On June 24th of 2018, where were you assigned?
I was assigned to, I believe at the time it was called TRUE, Tactical Response Unit, which is now a Tactical Service Section.
And what kind of work did you do in that section?
We were majority on patrol. We also did high crime areas, special areas in Detroit, along with events or any major thing that was going on in the city.
Before June 24th of 2018, did you know a woman or a judge named Tracy Green?
No.
Before June 24th of 2018, did you know two young men, 11 and 13 years old now, Russell Davis Head or Gary Davis Head Jr.?
No.
Did you, before June 24th of 2018, did you know a father by the name of Gary Davis Head?
No.
Were you called to or dispatched to an address 12730 Manor in Detroit?
We were flagged down by CPS in that area.
Okay.
And then
Let me stop you. What does CPS stand for?
Child Protective Services.
And when you say flagged down, could you explain better what you mean by that?
My partner and I were on patrol just in the area, and we saw two ladies and they saw our police car, and they just literally flagged us down and asked us if we could help them, and they identified who they were and that they worked for Child Protective Services.
Were you in uniform and in a squad car?
Yes.
Was your partner in uniform?
Yes.
Did you assist the CPS workers?
Yes.
What did you do?
Once they notified us that they needed help, and they would like us to make that location with them on Manor, my unit, Tactical Service Section, had their own radio channel. So I notified the other units in the area, along with my supervisors, that we were going to make this location with CPS. And then I went over our car radio to let dispatch know that we were flagged down by Child Protective Services, and we were going to assist them in making this location for a well-being check.
What time of the day was it that the workers flagged you down?
I believe it was like mid-morning, early afternoon.
Okay, are you guessing or do you know that for sure?
I don't know 100% for sure. I just know it was shortly after we started work that day.
And what time did you start work that day?
believe it was around 11 o'clock.
All right, so sometime after 11. Is that
Yes.
fair to say? All right.
Believe so,
What
yes.
what did you do with respect to the situation on Manor Street?
When the CPS workers let us know what the issue was and why they had to make the location, my partner and I walked down the street because we were parked a few houses down from the location. We walked down the street with the two CPS workers that flagged us down, and as they knocked on the front door, my partner was behind them and I was off to the side on the side of the location.
Did you hear anything as you approached the home?
As I was walking up the driveway, I did. I started hearing a man yelling.
Could you make out the words he was saying?
He said that you think, I don't want to say the wrong thing. I'd have to look at my report just to make sure I got the wording correctly.
Would your report refresh your memory?
Yes, ma'am.
Your Honor, may she look at her report?
Yes.
My report states that I heard a man screaming, "You think you can just do whatever you want, don't you? Going behind my back. She doesn't care about you. I'm your dad."
Okay. After you heard that, what did you do?
I let my partner know that I could hear someone screaming, and because it was nice outside, so I could hear it clear from the side of the house. And then my partner walked over with me. And at that time, the gentleman who I found out was was Gary Head Davis, that he came to the side door.
Did he eventually let you into the house?
He had left the main door open and the screen door was shut. And at that point, he had come outside to talk to the CPS workers along with my supervisors. And I had opened the screen door because he had stated there was a child in the house.
So when you went into the house?
At that point, I just opened the screen door and it was a duplex. So I kind of screamed up the stairs for his son, whom he told me his name was Gary Jr., for him to come downstairs.
Did you see a young boy who identified himself as Gary Jr.?
Yes.
And did he come downstairs?
Yes.
Did you see any other children in the home at that time?
At that point in time, no.
Can you give us a physical layout of that portion of the duplex?
So the side door and then the stairs kind of went on an angle. And then there was another door that went to the lower part of the duplex. And then the stairs went back up and then it was like a weird L shape. So you go up and then around and then came back up. And that's where the upper part of the duplex was.
Do you know whether the Gary Davis Head family lived in the lower level or the upper level?
He said they lived in the upper level.
Okay. So you said you saw the boy named Gary Jr. And did you notice anything unusual about his body?
At that point, when I began to speak to him, no.
Eventually,
One moment, Ms. Weingarten, just to back up again, you said he said they lived upstairs. Identify the he.
It was the father stated that they lived upstairs. And also when I yelled up for the child, for Gary Jr., he came from upstairs and said they lived upstairs.
Thank you.
Did you go upstairs?
Eventually, yes.
But before that, you met with Gary Jr. downstairs?
Yes, in the stairway.
All right. And did you ever see any other children in the home besides Gary Jr.?
After that point, when I went upstairs, yes.
How did you get from the downstairs to the upstairs? What is the reason you went upstairs?
When I was speaking with Gary in the stairwell, I asked him if there was any other children in the house because the father had told us that he was the only child in the house. Gary stated, no, my two brothers and my two sisters.
Objection. This is hearsay.
Response.
Okay. It is hearsay and I'll avoid the question. So eventually, did you go upstairs and see other children?
Yes,
How many other children did you see?
there was 2 younger boys and 2 younger girls.
Did you eventually meet another boy named Russell?
Yes,
And did you meet a girl named Daisy?
yes,
Did you meet some very young children?
I did see them.
Did you have a conversation with Gary and Russell upstairs?
Yes,
Did you look at their bodies?
yes.
Why did you look at their bodies?
I looked at Gary's when we were in the hallway downstairs, the stairwell. He had shown me his leg. And at that point is when I asked for one of the CPS workers to come over with me so she could see the marks on his leg. Then
Okay, let me slow you down for a minute. What was Gary Jr. wearing?
he had on a t-shirt, red shorts, and looked like women's slippers, oversized slippers for his feet in the stairwell.
Did you see any marks on his body?
At that point, yes, he had said, please don't leave us here. And he had lifted up his,
Objection, Your Honor, this is hearsay.
he had stated,
Response. Just a second. If there's an objection, pause and let me resolve it before you continue. Ms. Weingarten, any response?
I agree, it is hearsay. We can move past that.
All right, we'll strike the question and continue.
Did he show you some marks on his body?
yes.
Describe for us what you saw.
On his leg, he had fresh red and black and blue marks on his legs.
Did you look at any other part of his body?
I just saw his legs.
Did he appear to be in discomfort?
He was very timid and taken back and
Objection,
crying.
speculation.
I can
In
try to lay a,
response.
oh, I'm sorry, Your Honor. I can lay a foundation.
Go
Okay, you said he was timid. What do you mean by that?
He was whispering when he would speak to me. And yeah,
Where was his father compared to where you and he were?
his father was outside probably 10, 15 feet from the door.
And was there a closed door or an open door between you and him?
Between me and the father, or me and Gary Jr.?
You and Gary Jr. and the father.
At that point, I was inside the screen door, but the screen door was still open. I was only halfway inside of the entranceway of the door.
Okay, so you described Gary as being timid and you said something else. What did you say?
He was whispering.
Objection, speculation.
I think he said, Your Honor, I think she said taken aback. Can I inquire what she means by that?
It's still objection, speculation.
I will allow you to ask the question of what she means by taken back.
Officer Adams, did you testify earlier that you thought Gary appeared to be taken aback?
Yes.
What did you mean by that?
He wasn't overly excited. He wasn't acting like a normal children of his age would act. He was quiet. He was shaking. He had tears. He was very almost mellow.
All right.
acting.
Did you and he then go upstairs?
At that point, once he stated there were other children upstairs and we had this conversation and the CPS worker had come over and seen the marks as well, she stated that she wanted to see the other children.
All right, so did you and the CPS worker go upstairs to see the other children?
At that point, the father said that he would let us go upstairs.
Objection, speculation. I'm sorry, objection, hearsay.
Judge,
Response.
it doesn't go to the truth of the matter asserted. It goes to why she did what she did.
Continued objection, Mr. Ashcraft.
Yes, Judge.
Right, I'm going to allow you to go ahead with this question. Go ahead.
You can tell us what the father said to you.
I was standing at the door halfway inside the house, halfway not. And the father stated, which I heard, "Miss CPS lady, you can't speak to my child." And I advised the father that I was speaking to the child. And at that point, we had asked if we could go upstairs. The dad stated, "Yes, but tell me why CPS is here." The CPS lady who had been with me started reading him the complaint of why that they were there initially and why the police were there with them. At that point, he said, "Okay, my supervisors were there. They stayed outside with the father. My partner and I, along with the 2 CPS workers that were there at the time, went upstairs with Gary Jr. and talked to the other children."
So how many police officers arrived at the scene in total?
At that point, it was my partner and I, my 2 supervisors, and I believe there was one other scout car for sure that made the location.
Were your supervisors in uniform?
Yes,
Was the other squad car or other car of uniformed officers?
yes.
And how many CPS workers arrived at the scene?
Initially, it was 2. When we went upstairs and spoke to the children, the CPS workers had called another CPS worker to the location. So in total, there was 3.
How many of the CPS office workers went upstairs with you?
All 3 of them,
So there were 3 CPS workers and yourself that went upstairs?
along with my partner.
So 5 of you total.
Yes,
When you got upstairs, did you meet Russell?
yes.
Did you see any marks on his body?
At that point, he had shown us marks on his arms and his hands and his legs.
What did the marks look like?
They were red, black, and blue, just like the ones on Gary Jr.
Did they appear to be fresh?
Yes,
Did Russell appear to be in discomfort?
he was shaking.
Objection, speculation.
Any response?
May I ask her some foundational questions?
Yes.
You said he was shaking. Did you see that with your own eyes?
Yes,
And do you mean he was physically shaking?
he was physically shaking. His voice was shaky when he would speak.
All right, and then did you have a conversation with the 2 boys about what had happened to them?
At that time, the CPS workers were talking to them, and my partner and I were in the room. We did not speak directly to the children at that time. We let the CPS workers stand there and ask them the questions they needed to.
Eventually, do you know whether their paternal grandmother, Tracy Green, arrived at the scene?
I was notified after we were there for a few hours that she was there at the location outside.
Did somebody make the decision to remove the children from Gary Davis Head Sr.'s custody?
The last CPS worker to make the location, I don't remember her name, she made that decision to remove the children from the location.
And did someone convey that decision to the boys, Russell and Gary?
She came up the stairs. I was sitting upstairs in the hallway area before you reached the duplex apartment, whatever it's called, with Gary Jr. and Russell. And she had come upstairs and told me and the boys that they were gonna go somewhere else. They weren't gonna stay.
Well, it doesn't go to the truth of the matter asserted, Judge. It's about what happened next.
Mr. Ashcraft, go ahead.
Judge, she's specifically asking what the communication was in terms of the intent of what it was as well. It's clearly hearsay.
I'm going to sustain the objection. Continue, please.
Thank you, Your Honor.
Whatever it was that the CPS workers told the boys, did you see how the boys reacted?
Yes.
First, let's start with Gary Jr. How did he react?
At that point, she had not told them who they were going to go to or where they were going to go once they were removed. She had just told them that they were not going to be staying at home. And they both, or excuse me, Gary Jr. and Russell both got excited and asked if they could go with their mother.
All right. Did there come a time when the boys were asked if they wanted to go with their grandmother?
They were not asked in front of me, and I was with the boys the whole time, along with the two younger children. The whole time the stuff was going on outside with the CPS workers, the grandmother, the father. My partner had come upstairs to let me know that their grandmother was there.
Objection, hearsay.
Okay, well, it doesn't go to the truth of the matter asserted, Your Honor. It goes to whether the boys heard the statement.
Anything
Whether-
further, Mr. Ashcraft?
Judge, it's the same objection as before. The intent of the question is to find out exactly what was communicated, and it was communicated by a partner to her.
Judge, whether Judge Green arrived at the scene or not is not relevant. So that it does not go to the truth of the matter asserted. The issue is what the boys said or felt, knowing that their grandmother was at the scene, if she was at the scene.
And Your Honor, the objection would be both hearsay and speculation. There's no base of knowledge of Officer Adams in terms of what they felt. And the information that they shared in response to anything would clearly be hearsay.
May I lay a foundation for an excited utterance, Your Honor?
Go ahead and lay your foundation. We'll go slowly so that I can see if there is going to be another objection. Go ahead.
And if I might, and I apologize for interrupting, I believe that the foundation that's being laid is also for a prior consistent statement, and it is not hearsay.
Go ahead, Ms. Ryan. I'm
So,
sorry.
For
I'm
Adam,
sorry,
Wait,
Judge.
one moment. Mr. Ashcraft.
Judge, I'm not sure how many people are going to be making objections here, but there's no prior consistent statement in the record upon which for something to be built upon.
we're getting there, Your Honor.
All right, let's take it slowly. Go ahead, Ms. Weingarten.
Okay, officer, you said you were upstairs talking with both of the boys after they showed you the injuries on their bodies.
Yes.
And can you describe for us how Gary Jr. was acting when the CPS worker and your partner were talking to them about being removed from the home?
At that point, my partner was still outside. It was just the CPS worker had come upstairs and let them know, because we had been up there for forever and they kept asking me what was going on. So I had radioed down to my partner via my prep radio to ask him if he knew what was going on. At that point, he sent the CPS worker upstairs, and in the hallway areas where she let them, Gary Jr. and Russell, know that they were going to be removed from the house.
Were you present when somebody told them that their grandmother offered to take custody of them?
Yes, I was sitting in the stairwell with both the boys at that time.
Who told them that their grandmother offered to take custody?
It was the last CPS worker that made the location.
All right, let's start with Gary Jr. first. What was his reaction to that statement that his grandmother offered to take custody?
He literally froze. His body stopped moving and he stopped talking.
Did he do anything else besides that?
Just at that point, that's all he did.
Did he say anything to you about that?
At that point in time,
Okay.
no.
Okay. How did Russell react when he learned that his grandmother offered to take custody?
He got quiet and stopped speaking as well.
Was there some discussion between the CPS worker and the boys about their grandmother taking custody?
At that time, no.
Was there a discussion a little later?
Yes.
How much later?
I'm not sure. It was less than a half hour.
Were you present when that discussion took place?
Yes.
Where were
I
you?
never left the boys.
Okay, so you were still upstairs with the boys?
Yes. I was the only officer that was up there, and I stayed with them the whole time.
All right. So did a protective services worker discuss with Gary and or Russell whether they wanted to go with their grandmother?
After after she walked away, the boys had spoken to me. And then at that point, I conveyed to my partner via my radio that I needed to speak to my partner. And my partner came back upstairs.
So in front of you and your partner, did the boys express how they felt about going with their grandmother?
They said it in front of me, and I got worried, and I relayed it to my partner, and I asked him to have the last CPS lady who made the location to come back upstairs so she could speak to the boys.
So first, let's talk about Gary Jr. What did he tell you about going with his grandmother that made you decide you should convey that to your partner and to CPS?
Objection,
He's-
hearsay.
All right, may I lay a foundation first, Your Honor, for an excited utterance, and then maybe another rule of evidence?
Your
Certainly.
Honor,
What
Just
he-
one moment, Mr. Ashcraft.
thank you, Judge. I don't think that disciplinary counsel has established a foundation for an excited utterance to date. That was what the objection or the objective was, for her to try to do that. The elements of the excited utterance have not been satisfied thus far.
I agree with him, and that's why this is another discussion, and I'm going to ask questions about the foundation.
You may continue to ask the questions for the foundation.
So when you talked with the boys upstairs about the possibility of them
Hold
going
on.
with, well, go ahead.
Pardon me. Sorry.
Did somebody just enter the room?
Yes, they left. I apologize about that.
All right, no problem. All right, so when you talked with the boys about the possibility of them going with their grandmother, how was Gary Jr. acting?
He stated that he did not want to go with his grandmother because his grandmother knew that the dad abused them,
Your Honor,
and
this
she never did anything
Just
about
a-
it.
just a moment. I think the question was, how was he acting? Is that right, Ms. Weingarten?
Yes,
that's
All right, so that's what I can hear the response to at this
I
time.
apologize. He got nervous and scared and started crying.
when you say nervous and scared, what did he do that led you to that conclusion?
Shaking, crying, just his voice was cracking. He began to show signs that he was uncomfortable, as in just fidgety and just scared.
Up until that point, had he cried in front of you?
Yes.
Your Honor, I think I've established the foundation for an excited utterance. May I ask what Gary said to her?
Mr. Ashcraft?
Judge, I don't think an excited utterance has been established. The necessary elements have not been. If I may have just a moment.
Certainly.
Just one moment, Your Honor, I'm sorry.
Certainly. Counsel, would you like to have a sidebar at this time, and we'll bring Ms. Jorgensen in?
That would be good.
Certainly.
All right. And so the witness is still here in the hearing room. We're going to another room, and we will be back shortly.
Oh.
All right, thank you. I think we're all back. And with respect to the objection as to whether or not a foundation had been laid a sufficient foundation for the excited utterance, I have overruled the objection. I will allow the continued questions in this area.
Officer Adams, you are allowed to tell us what Gary Jr. said to you in the condition that you've described him in with respect to whether he wanted to go with his grandmother or not.
He had stated to me that he did not want to go with her. She knew about what the dad was doing to them, about the abuse, and she would allow the dad to get them back and come and see them.
Okay, did you also have that same conversation with Russell?
They were both together. All three of us were in the hallway area together. And he said that he just didn't want to go with the grandmother.
Okay. Can you describe for us how Russell was acting when he learned that his grandmother offered to take custody of him?
He did the same thing as Gary Jr. He just froze. Gary Jr., excuse me, did most of the speaking at that point.
Did you observe Russell change from a frozen position to anything else?
When I said I would, I let the boys know, like, oh, I'll see if there's someone else. I'll talk to the CPS worker. And at that time, they both kind of just took like a deep breath and just relaxed and started talking to me about their game that they were playing again.
Okay, so Gary Jr. gave you an explanation for why he didn't want to go with his grandmother, but Russell did not. Is that fair to say?
Correct.
Okay. How much longer were you upstairs with the boys before something else significant happened?
A while. I just know that we were there for a long time. And once that was stated to me by the boys, like I had said before, I had radioed my partner to come up there, and then I had asked him to get the CPS worker.
Okay. Did CPS ever tell the boys who they were going to go with?
At that point, after she had talked about the grandmother, then the boys and I had the conversation. When she came back upstairs, the CPS worker came back upstairs, she and the boys talked. They had a conversation with her, and they told her, Gary Jr. told her exactly what he had told me. Again, I was standing there and I had never left the boys' side. So the whole conversation, I had heard it. And they said, the CPS worker said, well, we'll try to find someone else then.
Did they ever tell did CPS ever tell the boys, we did find someone else, this is who you're going to go with?
Yes. After a while, after that other person, the lady that we dropped them off, the house we dropped them off at was cleared, then yes, they had been told where they were going.
Okay, did that conversation happen upstairs in your presence?
Yes.
And how did Gary Jr. react to the news that he was going with whomever it was they were placing him with?
They got excited. Gary Jr. got excited. Russell got excited because they knew who the person was and they liked the person.
Okay. Did you then escort the boys out of the house?
My partner and I, at that time, we did escort both the boys and the two younger ones out of the house.
Did you drive Gary and Russell anywhere?
My partner and I did not. That they were driven by the other scout vehicle, TAC 1, that had made the location because of the car seats with the two younger ones. My partner and I had them, the two younger kids, with their car seats in our vehicle.
Okay. Before the boys left their home, did they pack?
I believe I told them just to grab something that they needed or they wanted, but they didn't pack like bags and bags of clothes, no.
Did you see whether they took out any electronic devices?
They made sure that they had their iPads.
Did you see that with your own eyes?
Yes.
And Did their father have anything to say, just as a yes or no, about whether or not they could take their iPads?
Yes.
Did he allow them to take their iPads?
No.
Did he take the iPads away from them?
He didn't physically. We had given them to the father because he did not want them to take them.
Okay, so you asked the boys to hand them to you and then you handed them to the father?
I handed them to the CPS worker. The CPS worker handed them to the father.
How did the boys react? Don't tell us what they said. Just tell us how they reacted to the fact that they could no longer have their iPads.
They both were like, no, like those are ours.
Okay, and when they were driven away from the scene, did they have their iPads or were they taken away?
They had been taken away.
Since then, have you seen the boys?
No,
Have you had any communication with them?
no.
Right, Your Honor, may I have a moment to check my notes?
Certainly.
And if I could have just a quick moment to run down the hall to consult with Ms. Weingarten, it'll take just a second.
All right, one moment. Is this a good time to take a break? A
For us,
10-minute
it
break?
could only be a brief one, I think, but certainly.
All right,
I will be requesting a short break, Your Honor, before I do my cross-examination.
all right. At this point, though, let's just take a 5-minute break right now. It's been a while.
Okay.
Thank you.
Microphones on mute, please. Just waiting for Mr. Ashcraft.
Sorry, Judge.
All
I
right,
thought I hit that button.
not a problem. Ms. Weingarten, additional questions?
Just a few from Officer Adams. Officer, before June 24th of 2018, had you ever known any of the 3 protective service workers that you met that day?
No.
Do you know any of their names?
Not offhand. I would have to look at my report to get any other names.
Would that report refresh your memory?
Yes.
Your Honor, could she look at her report?
Yes.
One of them was LaShayla Miller Metz.
Could you spell that for us, please?
First name LaShaya. It's going to be LAS as in Sam, HAYLA. Last name is Miller, MILLER hyphen Metz. METTS. The other one is Leslie Apple,
Can you spell Leslie for us?
LESLIE. She was the last one to make the location, and Miss Miller Metz. And the other one is Shelly Gambino.
And spell her names for us.
First name is going to be SHELLY. Last name is Gambino, GAMB as in boy, INO. Miss Gambino and Miss Miller Metz were the ones that flagged us down.
Okay, thank you. One more thing. Did you know when you were flagged down that there had been a police run to the home at 7:50 in the morning that same day?
No, not at that point.
Thank you. I have no other questions.
Thank you, Mr. Ashcraft. You had indicated that you'd like to take a break before cross-examination. Is that true now?
Judge, the break you just afforded was fine, so thank you.
All right, thank you. If everyone is ready, then Ms. Weingarten will continue with the cross-examination by Mr. Ashcraft. All right, proceed.
Thank you, Your Honor. Officer Adams, if you weren't aware of the run from earlier that day, how did you know the name Gary Davis Head?
Once we made the location, and with the fact of our body cameras, every person that we speak to, we must get their name. That is how I ended up finding out who he was when we made the location, and I had asked him for his name.
So you asked him for his name. You didn't call for him.
I never called for him, no.
Now, the boys told you that the reason they wanted their iPads was because it was the only way they could communicate with their mother, correct?
One moment. Is there an objection, Ms. Weingarten? You are muted.
Yes, objection, hearsay.
Mr. Ashcraft.
Judge, I think that you already cleared an excited utterance with this entire line of communication, the entire line of questions.
Ms. Weingarten?
I think that the only excited utterance that we sought to admit was how Gary Jr. felt about going with his grandmother. There was no other statements that we moved to admit as an excited utterance.
Mr. Ashcraft, anything further?
Nothing further, Judge.
The objection is sustained. Continue.
Thank you, Your Honor. Who was your partner at the time of this call, Officer Adams?
Officer Christopher James.
Spell the last name, please.
J as in John, A as in Apple, M as in Mary, E as in Edward, S as in Sam.
And when did you last speak with Officer James regarding this run?
A few weeks ago when I asked him if he got subpoenaed for this as well.
Did you talk about any specifics in terms of each of your respective recollections of the run?
No, sir.
You reviewed your report before appearing today to testify, correct?
Yes,
When did you receive it?
yesterday.
And how much time did you take to review it?
Off and on throughout the day while I was at work and a little bit when I got home from work.
How many hours did you work yesterday?
I worked from noon to 10:30 last night.
And throughout the day, during the course of those hours, you had occasion to review your report, and you did?
I didn't get my report until later on in the afternoon. And due to the workload, I only had a little bit to look at it when I was at work.
And you reviewed it when you got to your home last night?
Yes, before I went to sleep and then had to be back here at work this morning.
Did you do any other investigation or anything else to refresh your recollection?
I just looked at my report, sir.
Did you speak with anyone?
Only to my sergeant to let him know that I needed a copy of my report.
Did you discuss that particular run of June 24, 2018 with him?
No, sir.
Did you discuss your testimony with anyone else?
No, sir.
Now, you did complete your report with regard to this run, correct?
Yes,
This run occurred on June 24, 2018, just 3 weeks shy of 3 years ago, correct?
yes,
And you included every important detail that is relevant to the investigation that you observed or did on that day, June 24, 2018, correct?
I would say I did most of it, probably not as every single detail.
And you made a report of your observations and activities on that day, the same day, right?
Correct.
So when you wrote the report, you had a pretty good recollection of what happened, right?
I wrote the report hours after we initially got to the incident.
But that wasn't my question. My question was, when you wrote the report, you had a pretty good recollection of what happened, correct?
At that point in time, yes.
And you used the report today to refresh your recollection before you even appeared to testify, right?
Yes,
And you used your report to testify at the juvenile court proceedings in 2019, right?
I believe it was 2019 that we went, but I did use it when I went to court, yes.
Thank you. But there you actually had your report in hand the entire time you testified, didn't you?
I don't believe I had it in hand looking at it the whole time, but I did have it near me, yes.
Because you had trouble remembering the details of this matter even back then in 2019, right?
There are certain details of specific things, such as names or specific things that occur that I wanted to make sure were correct. So it's not that I didn't remember, it's the specific instances or the specific names, such as the CPS workers, that I did not remember.
Well, was your recollection better in 2019, 2 years ago? Or is it better today, 2021, 3 years?
I would say that it is about the same.
Is it safe to say that today, 2021, you don't remember details of this investigation from so long ago?
I'm sorry, sir, you broke up. Can you repeat that?
Is it safe to say that today, in May of 2021, that you don't remember a lot of the details of this investigation that occurred in June of 2018, right?
I would not remember them as specifically as the day that they are actually occurring, but I do remember them.
And you certainly don't remember today, 3 years later, as well as you did on the day of the events, right?
No, because it's not happening right in front of me as it goes.
I'd like to understand your report a little bit better. How many pages are in your report?
I would have to look at it to get the specific numbers of how long the actual narrative report is.
Your Honor, may she look at her report for the purposes of my next questions?
Certainly.
Thank you. Officer Adams, you can get your report.
The narrative itself is,
No, my question, I'm sorry, Officer Adams, was how many pages are in your report?
the total report from all the information is going to be, mine is going to be 9 pages.
And the first page at the top, does it say second police run written in handwriting?
I have nothing in handwriting, sir.
In the top right corner of your report in handwriting, does it say Tillerson?
I have, again, I have nothing that is handwritten, and there's nothing that says Tillerson until the bottom left of my report.
On the bottom right corner of the report, does it say page 1 in a field and then June 27, 2018, 16:50?
Mine does not, because mine was printed yesterday.
So the only difference then, what I just asked you, is the date and the time.
Correct.
What is the
And
date
there's
and the
nothing
time?
handwritten.
What is the date and the time that you have on the bottom right corner of your first page?
Date is 5/26/2021, 16:37.
That's 4:37 in the afternoon.
Yes, sir.
And your second page, does that page consist of 9 individuals identified by name and address?
Yes.
The third page, does that page consist of 2 individuals identified by name, address, and personal information?
Yes.
The fourth page, does that have the block listing of all your assisting officers that day?
Yes.
The fifth page, is that the beginning of your narrative?
Yes.
And your narrative runs from the top of page 5 through all of page 6, through all of page 7, and through roughly the top half of page 8, correct?
Yes, sir. Yes.
Those 3.5 pages of narrative are single spaced, correct?
Yes.
Now, if you would please tell me what your page 9 is.
Page 9 states incident report suspect list.
Thank you. Now, if you would please go back to your first page, and I direct your attention to the top right corner. The top right corner says date, time reported 6/24/2018 at 12:48, correct?
Yes.
And then the bottom field says at found. What does that mean?
The date and time would be the time that we initially made the location or were flagged down at the location. At found is going to be the same date and time. I don't know why. That's just how we were taught when we got this new SunGuard Superion system, that you put the same date, time for last known secure and at found that you did for date and time reported.
Does it show in your report anywhere, Officer Adams, the time you actually arrived?
Not in the exact time. No, not on this report. That would be on the CAD system of when I let dispatch know and they put us on the run. The date and time reported would be as close as possible, usually to that I could get. But I don't know the exact time we were flagged down and dispatch put us on that run.
The bottom left corner of the first page, there's a reference to Tamara Tillerson, correct?
Yes.
Who's that?
It says that she is detective for SVU, which is the Special Victims Unit.
If you would please turn to page number 5 of your report and direct your attention to the top left corner. Are you with me?
Yes, sir.
It says June 24, 2018, 1709. Does that mean 5:09 p.m.?
On the top of page 5.
Yes. Top page 5, left corner.
1709, that would be when I initially started my report. That is
When you
my
say-
timestamp of when I started it.
So when you say initially started your report, that mean that's when you got back to the station and began writing down what you recall occurring at the scene?
That means that at that point in time was when I began my report inside of our police vehicle to start the narrative.
4 hours and 21 minutes after the date and time that you have in the top right corner, as far as at found, right?
I stated that we were at the police run for a very long time, for many hours, and I never left the children upstairs. So at that point, I was not going to start my report and leave the children upstairs unaccompanied.
So you were with the children for 4 hours and 21 minutes?
As long as my body camera and as long as the computer system says that I was there upstairs, that's how long that I was there.
Well, do you agree with me that between 1709 and 1248, that's 4 hours and 21 minutes?
I would agree that that's close. Yes, sir.
And this entire time, you were at the scene and with the children before you returned to your cruiser?
I was at the scene with the children, conveyed the children to the location that they were taken to, and then started my report.
So 1709 reflects the time when you were with the children and then you took them, or you went with them to their location, and then you started drafting your report, correct?
1709 is the time after the children were dropped off, and I started my report.
Thank you. And did you start the report at the station or in your cruiser?
The report was done all in my police vehicle.
And did you rely upon handwritten notes in preparing your report?
Yes, sir.
And where are those handwritten notes now?
Probably somewhere at home in a box with the rest of my notepads that I have.
You had access to those notes at the time you were creating the report, beginning at 5:09 p.m. that day, correct?
I had my notes in my memory. Yes, sir.
And did you complete the report beginning at 5:09 and continue until it was done?
As long as we didn't get sent to a priority or no officer called for assistance, then yes, I would have completed it the whole time until I was cleared from being done with my paperwork.
And you don't recall whether or not that occurred in the interim, right?
No, sir.
There's no indication on your report as to when you completed the report, correct?
I don't believe so, but I'm not sure.
Well, you can look at your report to see if there's a time signature someplace that reflects when you completed your report.
It doesn't look like that. There is, that would have to be on the CAD system.
So on page number, strike that. Your duty as an officer of the Detroit Police Department is to accurately record events that occur during the course of a call, right?
Yes.
You certainly have to record anything of significance in great detail, right?
Due to body cameras, I don't have to physically record anything handwritten, but everything is recorded either handwritten or on the body video camera.
Thank you. If you would please look at page number 5 at the top. This is where you indicate you start your narrative, correct?
Yes, sir.
There's not a single reference to Judge Green on that first page of your narrative, is there?
Well, I started the report from the beginning of the incident. So no, she would not be on the first page of my report.
Thank you. If you would turn to the second page.
Page 6.
Yes, that is a complete page, single space of your continued narrative, correct?
Correct.
There's not a single reference to Judge Green on page 6 of your narrative, is there?
Not at that time, no.
Well, not at that time, though. What
No,
does that
she's
mean?
not on that page.
Okay, now turn to page number 7, if you would. Page number
Yes, sir.
7 is a full page of your single space narrative continuing, right?
Yes, sir.
There's not a single reference to Judge Green on page 7 of your narrative, is there?
No, sir.
Look at page number 8 of your narrative, the top page, single space down to roughly the middle of that page. There's not a single reference to Judge Green in that narrative, is there?
No, sir.
There's not a single reference to Judge Green anywhere in your police report of June 24 of 2018, is there?
No, sir.
You have no individual recollection of this, do you?
That's not true.
Did you consider the things that were said by the boys that you seem to recall today something that was significant that should be in your report?
Yes, I should have put it in my report.
And you didn't.
At that time, no, I did not.
You have no document upon which you're relying to refresh your recollection on that, are you?
Except for my memory, due to the fact that this is the first child abuse where I've taken children out of the house. And even though it's not in my report, does not mean that I don't remember it clearly enough to remember certain things.
So it was a startling event for you because it was your first child abuse incident where you removed children from the house, but you didn't put in your report the specific details of what the children said about being removed from the house, right?
I would say yes, sir.
You testified in your direct examination that you observed Gary and Russell dealing with these startling events. Do you recall your testimony?
You would have to be more specific on which part of my testimony that you were speaking of.
About their concerns and how they reacted when they heard that they were going to be, or that their grandmother offered to take them. You recall that?
Yes,
There's not a single reference to that in your report, is there?
no, sir.
That's because you didn't remember them, correct?
That is not true.
That's because Gary and Russell, in fact, did not say those things to you, did they?
That is not true. They did state those things to me.
Your report does not say a single word about Judge Green, right?
Objection
just-
has been answered.
Overruled, continue.
Thank you, Judge. You may answer the question, Officer Adams.
Can you repeat the question, sir? I apologize.
Yes, your report does not say a single word about Judge Green, correct?
No, it does not.
So I'm correct?
You are correct in the fact that my report does not say anything about Judge Green. Yes, that you are correct about.
Thank you. In fact, your report doesn't say a single word about the boys being told that they may go with a grandmother, correct?
You are correct that my report does not state that.
Well, it references Gary whispering to you, does it not?
At which point in time, sir? And which page?
On page number 6, you document that Gary whispered to you, please don't leave us here. You see that?
Yes, that was right at the beginning of the incident.
Well, beginning of the incident, but that's the second page of your single space narrative, isn't it?
If you look at my report and
Is
the
that
first
correct?
page states, it is on the second page, yes, sir. On page 6, yes.
That was important enough for you to record, right?
Yes, sir.
And it was important enough for you to record you sitting inside the house having a conversation with the 4 children, right?
With the CPS workers talking, yes.
On page number 7.
And there was
third from the
5,
bottom.
there was 5
Excuse-
children.
Thank you. On page number 7 of your report, the third full page of your single space narrative, third to last paragraph, you're talking about sitting inside the house with Gary Jr., Russell, Daniel, and Kaylin, right?
Be the 5th paragraph from the top, yes.
And that was while CPS was trying to find a safe house for the children to go to, right?
Yes, sir.
But the events that you testified to today with regard to how Gary Jr. and Russell reacted to allegedly hearing that they were going to be going or could be going to their grandmother's house, that wasn't important enough for you to put in your narrative, was it?
Not stating that it wasn't important enough, but I did not put it in there.
There's not a single reference to a startling event in your narrative, is there?
Besides the fact of the bruises on the children and incidents speaking of the belt that was used and the bruises that I'd seen, I guess those would be the startling things that I saw at that event.
There's not a single reference in your report to a startling event related to where the boys were going to be taken, correct?
No, sir, just that they would be moved to a safe house.
There's not a single reference to nervous excitement demonstrated by the boys upon learning that they were going to be taken from the house, right?
No,
There's not a, I am right?
you are correct. Yes.
Thank you. There's not a single reference in your report to a spontaneous utterance by the boys, either of them, when they learned that they were going to be taken from the house, correct?
You are correct.
There's not a single reference in your report to the boys being in shock, correct?
Not in my report.
Your report does not make a single reference to Judge Green, let alone that the boys were ever in her proximity at the house that afternoon, correct?
The boys were not in her proximity.
Well,
So
you
no, that
testified-
would not be in my report.
You testified a little earlier that you learned that the grandmother was on the premises, did you not?
She was outside and the boys at that time were inside the house. So no, they were not in exact proximity to each other.
Did you ever see Judge Green?
Not until I walked the boys out of the house.
And did you see Judge Green when you did that?
At that point, I didn't know who she was. I didn't know her name. I just knew she was the grandmother.
How did you know that?
I was notified by my partner that the grandmother was over by the vehicle with the father.
Your report doesn't make a single reference to Judge Green being on the premises, does it?
No, but my body camera did.
Let me ask you how you came to be at the Manor home that afternoon. Was it specifically because you were flagged down?
Yes, sir.
You were flagged down to escort the boys to escort CPS to the Davis Head home on Manor. Is that right?
They had flagged us down and asked us if we could, because they had made a call and waiting for a scout, and they saw us and they thought we were the scout that was sent over there.
They wanted you to stand by while they investigated some domestic violence complaints that they had received that day. Isn't that right?
I believe it was that day that they had the complaints.
And when an elderly lady opened the door, you asked for Gary Davis Head, didn't you?
I did not.
He's the father and Judge Green's son, right?
As far now that I know that, yes.
When you say now that you know that, are you changing?
After all the court cases, I found out that she was a judge. But at that point in time, when we initially made the location with CPS, I did not know anything about Judge Green because she was not at the location.
Did the boys seem to be comfortable with you when you sat with them?
They were talking and showing me games on their iPad, and they seemed like they trusted me.
You understood that they were using their iPads to communicate with their mother without their father's knowledge and consent.
Objection to the hearsay.
Response, Mr. Ashcraft.
I didn't ask for any specific statement. I asked whether she knew that was true.
Well, the only way she would know that was true is if somebody told her that. So it's hearsay.
But not if I ask her what was said, that would be hearsay. I agree, but not whether or not she had that base of knowledge.
Well, then in that case, her state of mind is irrelevant.
Any further response?
No, Judge.
Objection is sustained. Continue.
Thank you. You testified earlier that the boys told you that their dad would not allow them to have contact with their mother, correct?
Objection to the hearsay.
It's prior testimony in this proceeding, Your Honor.
It's still hearsay, Your Honor.
It was testified to already on direct examination at the behest and the request of disciplinary counsel.
I don't know that I asked a question about that.
Ask your question again. Don't answer. Mr. Ashcraft, ask that again and let's see.
Thank you. The boys told you that their dad would not allow them to have contact with their mother, correct?
Judge, I did not ask that question on direct exam.
I do not recall that question, Mr. Ashcraft. If you need, we can take a break and ask the court reporter to look in the record for us.
Not necessary, Your Honor. I'll move on.
Thank you.
When Gary Jr. looked in a closet to show you the belt his father used to discipline him, he could not find it, correct?
I would have to look at my report.
You have no recollection of that?
I remember he looked for a belt. I do not remember if it was in the closet or not.
Did he tell you that his father was wearing the belt that he used to discipline them?
Objection to the hearsay.
Response, Mr. Ashcraft.
I'll move on, Judge.
All right.
Both Gary Jr. and Russell voluntarily showed you the bruises on their legs, correct?
Gary Jr. voluntarily showed me specifically the bruises on his legs in the hallway stairwell. Russell showed his marks to me, my partner, and the CPS workers upstairs voluntarily.
How long did you talk to them alone?
Just a second. Could you clarify what you mean by alone? Or I
Yes.
don't know. Yes, go ahead.
Thank you, Judge. How long did you talk with Gary and Russell when it was just you and the two of them?
I was upstairs in the stairway before the apartment with them for probably a few hours talking about everything. Games, things that they enjoyed, things they didn't enjoy, school, not school, normal child conversation with them, as well as other conversation that they brought up.
And neither Gary Jr. nor Russell told you that they had been tied to a bed and beaten with a belt, did they?
Objection to the hearsay.
Response.
Judge, it's the same thing that we've gone through already. This is part of the report of the indication, the testimony of the officer. It's the time, or around the time, I believe, of the excited utterance that's been recognized.
Objection is sustained. Continue, please.
Thank you.
Can you repeat your question or?
You
Again, please.
testified.
One moment. I did sustain the objection. Mr. Ashcraft, would you like to make a separate record?
No, not necessary, Judge.
All right.
Thank you.
Continue. Mhm.
You testified on September 13, 2021. September 13, 2019, before Judge Paul Cusick in the Third Circuit Court, correct?
I'm not sure of the date, but that judge's name sounds familiar.
And there you described the bruises the boys showed you as appearing as though they had been hit with a belt, right?
Yes.
No one mentioned any whips, correct?
Objection to the hearsay.
Response, Mr. Ashcraft.
Not asking for any specific statement by any individual. I'm simply asking generally to confirm that no one mentioned any whips.
Well, that is an out-of-court statement by somebody. So that's hearsay.
Mr. Ashcraft, any further response?
No further response.
Objection is sustained. Continue.
Thank you. You also testified during that hearing that you took a look around the house, correct?
Yes.
When you took a look around the house, you didn't find any whips, did you?
Not that I was specifically looking for.
You weren't specifically looking for whips?
No.
Are you trained in the forensic protocol for interviewing of children?
No, I never interviewed them.
Who was Samir Choucair, Choucair?
Can you repeat that, please?
Yes. Samir, Samer, last name Choucair, Choucair.
I have no idea.
Who is Todd Push, Push?
No idea.
Are you supervised by, or strike that, were you supervised back in June of 2018 by a particular investigator?
I was not supervised. No, not by an investigator.
Or did you have a supervisor?
I had two supervisors at that point in time.
Their names, please.
Sergeant Timothy Barr, and Sergeant Donald Covington.
And if you would please tell me again about Officer or Detective Tillerson.
I don't know who that is.
Okay.
I never spoke to them.
When you appeared at the house sometime after 12:48 p.m. on June 24, 2018, did you try to find out whether there had been any other activity earlier in that day at that location?
I had asked dispatch via our in-car radio if there had been any incidences at that location to where police had made the location due to CPS stating that there had been incidents at that house earlier that day.
What did you learn?
Objection, hearsay.
It's not being asked for purposes of the truth of the assertion, Judge, just whether or not she learned information that was important before she arrived at the house when she did.
Further objection, Ms. Weingarten?
Well, I think it's hearsay.
Right, so Mr. Ashcraft, I think I heard you say two things. One, you asked what was said, and then you said in response to the objection that it was asked to find out whether or not she heard significant information. So tell me what it's going to be used for, and then re-ask the question.
Sure, thank you, Judge. I want to find out whether or not there was information that she obtained that was important for the health, safety, and welfare of herself as an officer, CPS investigators that were flagged her down, etc., before they proceeded to the house.
Judge, I have no objection to her answering yes or no to that question.
Restate your question, Mr. Ashcraft, and before you answer, officer, let's hear if there is an objection. Continue, please.
Did you speak with someone at the department or dispatch or otherwise investigate whether or not there had been any incidents or occurrences, specifically runs or calls, to the manor house before you arrived that day?
You may answer.
Yes,
And was the information that you obtained information that was important for you to know before you went on that call?
You may answer.
all the answer was is that there was a 911 call there earlier in the morning or earlier that day, and that was it.
Did you have occasion to speak with any officer that had been there earlier in the day?
No,
Is corporal punishment illegal in the state of Michigan?
Objection,
What's
no
the objection?
foundation. There's no foundation for her to know that.
Mr. Ashcraft, response.
Judge, if she's an officer of the law, I would think that she would know whether or not corporal punishment is illegal in the state of Michigan, such that she should be aware whether she has to exercise her responsibilities of potentially arresting someone for violating the law.
Further objection, if any, Ms. Weingarten.
I don't think he's established a foundation that she knows what the law is with respect to that.
Mr. Ashcraft,
Judge, I'm happy to establish a foundation.
proceed with that.
Thank you, Judge. Officer Adams, do you know whether corporal punishment is lawful in the state of Michigan?
I am drawing a blank right now, sir. Not gonna say anything else to that.
I didn't hear what you said. You're not going to what?
I don't know what else to say to you to that, is that I'm drawing a blank right now.
You just don't remember?
Not right now, no.
Did all the officers and investigators leave the house on Manor that afternoon at the same time?
There was no investigators that made the scene when I was there, and my supervisors left before my partner and I did, and also before the other scout car that had the two boys in it. They left slightly before us, and then the TAC 1 and my partner and I left at the same time.
All 5 of the children were removed, correct?
Yes,
And were they all removed and taken away from the premises at the same time?
no.
What was the order?
Daisy's mother showed up first, and Daisy was taken from the location by her mother. And then the other 4 children were removed at the same time.
No one arrested Gary Davis Head, correct?
Not at that time, no.
Even though they saw bruises on the children, correct?
I'm sorry, you broke up. I apologize.
Yes, my follow-up question was, even though you saw bruises on the children,
I was following orders.
and the children also told you that they had been disciplined with a belt, correct?
Objection to the hearsay.
Response, if any.
I'll move on, Judge.
Thank you.
In June of 2018, how many calls did you respond to on average in a given day?
I have no idea. We
You don't
weren't
have
my unit is not a unit that answers police runs on a daily basis. We are an assisted unit, unit, which means we go into specific areas that we are told that day to go into per our supervision. And other than that, we help with police runs if needed. We volunteer for police runs if they are overloaded in police runs in whatever district that we were in. Otherwise, we were on random patrol through the neighborhood, doing tickets, tows, anything of that nature.
So you don't have an estimate for us in terms of how many runs on average that you would make in the course of a day?
Not while I was at the tactical service section. No, I do not.
How about in a week?
I do not. Again, we were not a unit to specifically answer police runs. So no, I do not know.
And your answer would be the same if I ask you how many in a month?
Again, do not know, because we were not specifically sent to answer police runs in any area unless we were told to.
How long were you in that unit?
I am currently assigned out from that unit. But prior to that, I have been it was the park unit, which turned into the tactical response unit, which then turned into TSS, which is the tactical service section. And I have been there permanently approximately 5, maybe 6 years.
Thank you. We've established that there is no reference to Judge Green in your report, correct?
Objection asked and answered.
Any response, Mr. Ashcraft?
Yes, Judge, I would appreciate just a little bit of leeway here as I ask 3 final questions.
I will allow you to ask the 3 final questions. Go ahead.
Thank you. We've established that there's no reference to Judge Green in your report, correct?
Yes,
We've established that there's no reference to the events that you testified about today regarding Judge Green in your report, correct?
correct.
In fact, you never mentioned anything about what you testified concerning today as relates to Judge Green to anyone at any time until almost 3 years later in February of 2021, when you received a call from Ms. Weingarten, the disciplinary counsel, correct?
I believe in the other court cases that it was brought up. Judge Green at some point in time was brought up when we were at juvenile court and at Third Circuit Court in some type of, capacity. But besides that, no.
So I'm correct?
For the fact that it's not in my report, and that is what you're correct about.
And other than you believing that there may have been some reference during a juvenile court hearing where you testified, you have not shared any information about what you testified today concerning Judge Green at any time to anyone until February of 2021, when you received a call from Ms. Weingarten, correct?
It's at Third Circuit, and I'm not sure the date of when Miss Weingarten contacted me, but it was sometime earlier this year.
Judge, may I have just a brief moment to check my notes and speak with my client?
Certainly.
Thank you kindly. Your Honor, we're going to take a couple-minute break to do this, or?
We can if we need to. I didn't know if you were just going to go on mute.
If I may just have 3 minutes, it would be appreciated.
All right, we'll take a 3-minute, we'll take a 5-minute break then.
Thank you.
Please mute your microphones. And whenever you're ready, Mr. Ashcraft, you're still muted.
Thank you, Judge. Just a couple more follow-ups, please.
Certainly.
Thank you. Officer Adams, you testified that Christopher James was your partner at the particular time, June 24 of 2018, during this run, correct?
Yes.
Is he still your partner?
Due to me being assigned out, we are not partners right now.
Do you draw straws, or how is it that you figure out which of the two of you will prepare the narrative in the report?
We had a mutual agreement because we worked together for 6 years that he drove and I jumped, which would mean that I was in the passenger seat. I did most of the paperwork.
Did he have an opportunity to contribute to your narrative?
He gave me the information of who he had contacted through, I believe, our child abuse or our SVU unit. He gave me that information because he was outside the whole time, well, most of the time, while I was upstairs with the children.
Did he have an opportunity to review your narrative and specifically the report before you, in essence, signed off on it?
I don't recall.
Do you know whether or not he made any revisions to your narrative?
I don't recall.
Do you recall any specifics of what he contributed to your narrative?
I believe I just stated he gave me the information for who he notified through either child abuse or SVU. I'm not sure which one it was that he contacted.
Thank you.
Thank you. Any questions on redirect, Ms. Weingarten?
Yes, Officer Adams, you testified that you were wearing a body cam, right?
Yes, ma'am.
Do you know for how long the department keeps body cam footage?
I believe it's 6 months, but I'm not 100% sure.
Do you know if anybody preserved your body cam from that day?
I would not know.
Have you and I communicated over the course of the last several months in preparation for your testimony here today?
On and off through email?
Okay, so is that yes?
Yes, sorry, yes.
Did this police run have an effect on you personally?
Objection, relevance?
Well,
One moment.
Mr. Ashcraft is making it look like she doesn't remember this very well, and I think she will tell us why she remembers it so well.
Further objection, Mr. Ashcraft.
Judge, that's not relevant to any issue and dispute in the case.
Ms. Weingarten, anything further?
Yes, he made it an issue by questioning her about why this and that isn't in her report and whether her memory is better today than it was 3 years ago, et cetera.
Right, thank you. The objection is overruled. You may ask the question. If you'd ask that again, please.
Okay. Officer, did this police run have an effect on you personally?
It stands out there. Like I said, I've been a police officer for Detroit for 13 years, and there are certain runs or certain instances that do stick out throughout my time. Like I said, this was the first one where I've dealt with child abuse issues before. This was the first one that we've actually had to remove the children from the house. And it may not all be in my report, which Mr. Ashcraft has clearly pointed out, but your memory of things, of smells, of things that were stated, of actions, most of those are easy to remember than sometimes explaining them or writing them down. The children, the two older boys who I spoke to, Russell and Gary, they were the sweetest boys that ever. And the way that they would talk to me or the ladies from CPS, and then the fear that you could see in their eyes and through their actions when they thought their father was coming up the stairs or when they thought they had to go with their grandmother. Those stick out in your memory. They're things that you just don't forget. Daisy, she was a sweetheart, and she wanted.
We've gone far afield of the question at this particular point. She's providing narrative.
Judge, I think she has answered the question. I'm satisfied.
Thank you. Continue, Ms. Weingarten, with your next question.
Officer Adams, was Tracy Green ever a suspect in the physical abuse against Russell or Gary Jr.?
Not that I knew of at that point in time at the police run.
When did you testify in the juvenile court trial where Gary Davis Head's parental rights were at issue?
Yes.
Were you asked any questions at that hearing about Tracy Green?
Just if she was there, if I knew who she was. That's all I remember.
Were you ever I'm sorry, I didn't mean to cut you off.
Okay.
Were you ever asked any questions about what Gary or Russell said to you about possibly going with Tracy Green?
At juvenile court, yes.
What about at the criminal court? Did you testify about what Gary or Russell told you about going with Tracy Green?
At Third Circuit, just the normal questioning. They didn't ask specifics about her using her name. They just asked how they were when they were told they were going to go with their grandmother.
Okay, so your recollection is that you were asked those questions at both the juvenile court and the criminal court, and you answer those questions?
Yes.
Did you, at the scene, did you share with anyone what the boys said to you about going with their grandmother?
I had told my partner, which at that point I had asked him to go get the last lady who showed up, which was Miss Apple from CPS. And all I told her was they don't want to go with their grandmother, but I told them they had to speak to you.
And then did the boys repeat to her their desire not to go with their grandmother?
Yes.
Thank you. I have no other questions.
Thank you. Any recross, Mr. Ashcraft?
No, Judge, thank you.
All right, thank you. May this witness be excused?
Yes.
All right, thank you. At this point, Mr. Helen.
Thank you, ma'am.
The only thing I wanted to do, Judge, is say that when you pick up again, I will be disappearing for some time, starting just before 2 o'clock. So I just want to alert everybody to that. I don't need to be a part of the proceeding during that time of disappearance.
All right, thank you. My understanding is that we are going to take a lunch break at this time. So let's break for about 40 minutes. And then I have that it's almost 1:15. So I'm going to say let's be back by 1:55 so that we can start up by around 2. All right. Thank you.
Thank you.
Please place your microphones on mute.
Thank you, ma'am.
Thank you, officer. Good afternoon.
Good
afternoon.
afternoon, Judge.
Good afternoon.
All right, there are a few people in the waiting room, and I think the next witness is Ms. Drysdale Crown. Is that correct?
She's the lawyer for the Attorney General's office,
All right.
Leslie Apple. But
Yes.
before you let them in, I have one stipulation to put on the record that I forgot to do before.
All right. Thank you. I'm ready to hear that stipulation.
Okay. Syretta, Syretta Brown, was the next door neighbor to Gary Davis Head, who on June 24th, 2018, called 911 at 7:50 a.m. to report suspected child abuse.
All right. Thank you. Anything further?
May I just ask if that's a correct stipulation, Mr. Ashcraft?
That is a correct stipulation. Thank you.
All right. Thank you. Anything further with respect to preliminary matters before we get back into the testimony?
Not for me.
All right.
Not for me as well.
All right. So my understanding is then that Ms. Apple comes in, and then also, is it both Harrington and Drysdale Crown? All right. Thank you. Now, I noticed that Mr. Herschel Fink is also in the waiting room. He is there for what purpose?
He shouldn't be this early. He is representing Mr. Elric, who is the third witness. And I just communicated with him by email telling him it might not be till 3:30. So I don't know why he's in the waiting room.
Okay. I don't know if you want to give him a call and just let him know it's still going to be a while, but I can just leave him out there. That's not a problem. Are you on mute?
I am not, so let me do that. Thank you. So I did not reach him, but I left him a message telling him to get out of the way.
All right, that's fine. I did let Ms. Apple in from the waiting room, and also there is a Ms. Drysdale Crown and also Erin Harrington. And those individuals are here because of the witness, Ms. Apple. Counsel, are you ready for us to begin with me swearing in the witness?
Yeah.
All right, thank you. Ms. Leslie Apple, if you will please unmute. All right, thank you. I'm Betty Widgeon. I am the appointed master in this case, and we're going to start with me swearing you in. Moment. Please raise your right hand. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth? So help you.
I do.
Thank you. You may put your hand down. What is your name?
Leslie N. Apple.
All right, and please spell that.
Leslie, middle initial N, last name Apple, Apple.
All right, thank you. Ms. Apple, before we start with your testimony, there were two orders that I asked counsel to uh, present, review with their witnesses, and one is a sequestration order. The other one is an order regarding hearing and witness protocol. Are you aware of those two orders?
Yes, ma'am.
All right, I'm going to go over the pertinent parts of those right now, and then I'm going to ask you if you have abided by those orders, and are you either swearing or affirming that you will continue to abide by these orders unless you are released or the hearing has concluded. All right. The first one is the sequestration order. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies, unless the witness is released by the master. Sequestration includes a prohibition on any witness, except while testifying via Zoom during the proceedings, from doing any of the following: discussing her testimony in any format or by any means with another witness, viewing the proceedings on any device, listening to the proceedings on any device, or accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to the discovery of the failure or the violation. Any questions about the sequestration order?
No, ma'am.
All right, thank you. The order regarding hearing and witness protocol pertinent parts. Counsel shall ensure that all witnesses have hard copies of the exhibits required for their testimony. Do you have hard copies of any exhibits that you are expected to testify regarding?
Yes.
Thank you. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in the room at this time?
Yes.
Thank you. No witness shall access or review any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. If a witness needs to refer to a document, she may do so only if invited to by counsel or approved by the master. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you so certify that no one has given you information by any means to assist in testifying that counsel and I cannot observe?
That's true. No one has.
Thank you. Witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during the examination other than the device they will use for their virtual testimony. Which device are you using to testify with today?
My laptop.
All right, thank you. Do you swear or affirm that you have abided by these orders?
Yes.
And also that you will continue to abide by these orders unless and until you are released from them?
Yes.
All right, thank you. Counsel, I think we're ready to proceed then at this time.
Good afternoon, Miss Apple. Can you tell us your whole name again?
Yes. Leslie N. Apple.
How are you employed?
I am a CPS worker employed with the state of Michigan.
And what does CPS stand for?
Children's Protective Services.
What is your educational background?
I completed high school. I have a bachelor's in communications and a master's in social work.
For how long have you worked for Child Protective Services?
I have been doing protective services since, I want to say maybe July of 2015.
And before that, did you also work for the state?
Yes, ma'am. I was a foster care worker from 2011 until July of 2015.
And as a foster care worker, did that involve dealing with children who had been physically and sexually abused?
Yes, ma'am.
You said that since 2015, you've been a child protective service worker.
Yes.
What are the duties of a child protective service worker?
We generally receive complaints of abuse and neglect, go out on the complaints, investigate the allegations, and generate a report. And sometimes children may have to be removed. Sometimes that's not necessarily the case. We may put services in the home to preserve the family.
Before June 24th of 2018, did you know a woman by the name of Tracy Green?
No, ma'am.
Have you ever met Tracy Green?
Yes, I have met her.
Okay. Before June 24th of 2018, did you know a man by the name of Gary Davis Head Jr.?
Before June 24th, yes, I met Mr. Davis Head Jr.
Before June 24th of 2018, did you meet a young man named Gary Davis Head Jr.?
Yes,
And Russell Davis Head?
yes.
Did you have any sort of personal relationship with any of the people I just named?
No,
Do you know whether or not Tracy Green was ever a child protective service worker?
I do not know.
And can you tell us, when you do an investigation in general, do you write any reports?
Yes. What
What is the name of the kind of report you write?
It's called our DHS 154. It's compiled of several different assessments that can make up the report.
Is it referred to as anything other than the number you just mentioned?
The 154, no, not to my knowledge.
Do people ever refer to it as an investigative report?
It can be referred to as an investigative report.
Is there a template that protective service workers must follow when they write the investigative report?
There's not necessarily a template. However, the report is generated through my SAQUIS. That is the automated system that the state has implemented for completing reports. So I would input my information into the system, and then once I'm finished, it would generate a report.
What is to be included in the investigative reports?
The facts, what happened, interviews, assessments. There's a risk assessment, there's a safety assessment. If there are police reports will go in there, medical reports, things of that nature.
So when you say there's a risk assessment, is that a point system?
Yes, yes, that is.
And you said there was some other assessment. What was that called?
There's a safety assessment and a risk assessment.
Is the safety assessment a point system?
Yes, ma'am.
Is the rest of the report written in words in paragraph form?
No, not necessarily. The report is comprised of social work contacts, if you will. So if I've taken notes or met with certain people and I go back and input what I've said or what was said in the conversation or communication, then it's put in sections.
But it's all words, not numbers or scoring.
Correct.
Okay. And when you, do you enter the information piecemeal, or is it all entered in at one time?
It's entered in as you go along.
When you're done with the report, what is done with it?
I submit it to my supervisor for review.
In June of 2018, who was your supervisor?
Mary Ann Kavanaugh.
Is she still your supervisor today?
Yes.
And what is the supervisor's role with respect to the investigative report that you've written?
The supervisor reviews it for accuracy. She would make sure that I have followed policy, and after she's made sure that everything is correct, then she would sign off on it.
Does the supervisor have the right to return it back to you for more work?
Yes.
Once she signs off on it, what is done with the report?
It's saved in my SACWIS system, and the case file is stored.
Do you generate something called a petition?
If a petition is necessary.
Okay, explain to us why it would be necessary or why it would be unnecessary.
It depends on the situation. For instance, if there is a case where there may be severe neglect or abuse, the worker may have to generate a petition, meaning asking the court to step in and to assist with placement for the minor child or children.
All right, in a situation where a petition is necessary, is there a template for the petition?
There is a template for the petition, yes.
And what things must be included in the petition?
So you put in the child welfare history for the family. You put in demographics for both parents. We put birth certificates in. If there's any criminal history for parents, we document that. We document if services have been offered to the family before the petition, and if services were offered, how the family did with the services.
All right, with respect to both the investigative report and the petition, does one person author both of those documents, or do more than one people contribute to them?
So it depends. As far as the investigation report, it depends on if you are the only worker working on that case. For example, cases, when workers receive cases, they may receive a case that an on-call team went out on over the weekend. So if an on-call team went out, then they would have put in documentation in that case as well. As far as a petition is concerned, I would put information into the petition, and then that petition is then given to my supervisor to review, and then my supervisor will give it to the section manager to review. And then once it's approved from the section manager, then it goes to the court intake office to review. And then after that, it will go to the court. Oh, and also goes to the AG's office for them to review it as well.
Does the Attorney General represent the Child Protective Services as a client?
Yes.
So it sounds like there are 5 or 6 steps in a petition being reviewed until it gets to a judge. Is that correct?
Yes.
And does a judge have the right or the authority to deny it or send it back for anything more?
Yes.
In your career so far, how many investigative reports have you written?
Oh, wow. I don't know, hundreds.
Okay, how many petitions have you written?
I don't know, maybe 30, maybe.
Are investigative reports completed before a petition is filed?
Generally, yes, depending on the circumstance. It's really case by case.
Are there times after a petition is filed that the investigative report is amended and more information is added?
I wouldn't say necessarily amended because if as long as your case is still open, you can always put information into it. Once the case is closed, it's closed.
And how does a case get closed?
It's approved by the supervisor.
Okay. Now explain to us, you said something about there being an on-call team. Explain to us what that is.
So the on-call team is in our office. It's comprised of 4 individuals and it's broken down by zip code. There's a team A and a team B. It's comprised of 2 individuals, and they will go out on any complaints that was received for a certain zip code together.
Can you tell me if the following 2 people are part of your on-call team? LaShayla Miller-Metz and Shelley Gambino back in June of 2018.
Yes, both of those ladies were, yes.
Okay. And if they go out to a scene, do they then become the worker on the case, or is it possible someone else could be assigned?
It's possible someone else could be assigned.
How is that decision made about whether one of them keeps the case or whether someone else gets assigned?
It's just random. It's something that they just go down a list. It's a rotation. So when your turn is up, you get the next case that comes, something like that.
If a worker has already met with a family and worked with them at one point or another, does that same worker get reassigned if there's another referral to protective services?
Yes.
Okay. I'm changing that now, the direction of our talk, and we have had testimony this morning from a police officer named Melissa Adams, who testified that you appeared on a scene located at 12730 Manor Street in Detroit on June 24th of 2018. Is she correct that you were one of the workers who were there?
Yes.
Were you one of the on-call workers, or were you a different kind of worker?
I was the assigned caseworker for that case, but I was not on call.
So on a weekend, did you get called in?
The on-call worker on the scene called me while at the location and told me she was there, and I went.
Now, because of that, were you like the supervisor of the protective services workers that day? Were you the one who made the final decisions?
No, the supervisor for the weekend was acting as the supervisor. She was the supervisor.
And was she at the scene?
No, she was not.
Were you in phone contact with her?
Yes.
Okay. Did you, when you went to the scene, did you have a communication with police officer Melissa Adams?
Yes.
Do you remember her?
Yes.
Okay. Did you also talk with anyone else at the scene?
Yes.
Okay. Did you eventually make a decision, or with your supervisor, make a decision that the 5 children should be removed from the home?
We're now getting, I object, Your Honor, we're getting specific to this particular incident, and we've already discussed this. A motion's already been filed with regard to it. This is something that is confidential, not subject to disclosure.
Okay,
Thank you.
I agree. I'm trying hard not to cross the line. So I agree. That's probably an improper question.
All right, that question is withdrawn. Continue.
After the time you spent at the Manor Street address, what did you do after you left there?
After I left the Manor Street address, I went home and went to work the next day.
Who determines whether or not a child should be removed from a home?
In what instance?
So this is a hypothetical. This is not related to this case.
Okay,
Who has the
I object, Your Honor. It's asking for a hypothetical question of a non-expert witness.
Response, if any?
I don't think it requires an expert witness to answer the question. It requires someone who works for protective services.
But Ms. Apple has not been proffered as an expert witness in this case, and you're asking a hypothetical question to, in essence, a fact or a lay witness, which I submit is not appropriate.
Any further response, Ms. Weingarten?
No.
All right, I'm going to allow that hypothetical question to be asked.
Ms. Apple, hypothetically, who decides whether or not children should be removed from what could potentially be an abusive environment?
the supervisor makes that decision with the worker. It's case by case. It just depends on the situation.
And who decides where the children should be placed?
Again, when I say we, workers, CPS, we generally try to place children in the most family-like setting. So we would try to place them with relatives if they are available.
Do you do some sort of safety assessment before you place them with a relative?
A background check.
Do you consider what the children want and where they want to be placed?
No, not necessarily.
Okay, so does not necessarily mean you never consider what the children want, or that sometimes you do, or what?
It means that at the time of the incident, we make the best decision for that situation. So for example, a child may want to go to grandma's, but that might not be the best decision at that time. They might want to go somewhere. We just make the decision for the best place at that time.
So do you consider whether the child does or does not want to go with somebody?
We only consider safety. So we place the child in the safest setting.
How do you do that when you don't know whether a setting is safe or not at that moment?
We go by the history, we do a background check. And if a child tells us that they are comfortable with the person that we're doing a background check on, then we gauge it that way. Also, safety plans are voluntary. So the parent, because a parent hasn't lost rights during a safety plan. So a parent has input on a safety plan person as well. So we take that into consideration also.
Okay, so you testified that a child's word about wanting to go to someone who's safe is considered. Is a child's statement that they don't want to go with someone who they feel is not safe also considered?
Yes.
Okay. And then when a child is removed and placed in a safety plan, for how long is the child with that safe person?
Well, it depends on the situation at hand. We do not like to keep children in safety plans. We like for them to be someplace settled and permanent. So it just depends on the situation.
So a safety plan is a temporary thing, and your goal is to find a permanent place.
Correct.
All right. Now, I want to get back to the investigations that you write. Are they written in every single case where Child Protective Services investigates?
I'm sorry, could you repeat yourself?
Sure. The investigative reports, are they written in every single case that a protective service worker investigates?
Yes.
And are they made in what we call, or what you would call it during the course of business? Is that the business of protective services to investigate and write these reports?
Yes.
How thorough are these reports supposed to be?
I'm not exactly sure what you mean by how thorough they're supposed to be. If you read a report and it's supposed to be able to answer to the allegations.
So what information do you put into that report?
You address the allegations and you provide information that will justify why whatever decision was made. So the decision may be to keep the children at home. There may be no evidence. You would put all the information in to justify why the children would remain there. If the decision is made to remove the children, then you would put in the report why the children are being removed.
Do you list each and every person you interview?
Yes,
And you summarize in a paragraph form or a couple of lines what each person told you?
yes,
Do you put the date and time or place that you spoke with the individual people?
yes,
And do you ever purposely leave out information from the investigative report?
no,
So if someone tells you something, you always put it into the investigative report?
yes,
Do you believe that you always do a full and fair investigation?
yes,
Have you ever been accused in the past of not doing a full and fair investigation?
yes.
Tell us the details behind that.
I was accused of being biased during this investigation.
Besides this investigation, have you ever been accused of being biased in the past?
No,
And you said you've done about, I forgot what you said, how many investigations?
hundreds.
Did anything come of the complaint that you were biased in this case?
We're now going specific and crossing the line into this specific incident.
Response.
I guess I want out there whether she was disciplined or fired or that kind of thing.
But she spoke without a question asked and volunteered information that is specific to the incident. And that's already been addressed and decided as being confidential and not subject to disclosure. And now you're following up on that information.
All right, Judge, I'll drop it. Okay,
Thank you.
just move on. Miss Apple, hypothetically, if you were investigating the possibility that a child was physically abused and you interviewed a person who told you that she put makeup on a mark on a child's face that was caused by physical abuse, would such a statement be important or unimportant to your investigation?
Important,
Why would it be important?
because it's a fact.
I'm sorry, go ahead. I didn't mean to cut you off.
No, it's something that was told to me pertinent to my investigation. So that's why it would be important.
Would you put it into your investigative report?
Yes,
Can you think of any circumstance in which you would not include it in your investigative report?
no,
What kind of training do CPS workers get?
we go through several weeks of training when we are hired in with the state. We go through the Child Welfare Institute. So it's 9 weeks of training.
Right, and then is there on-the-job training beyond those 9 weeks?
Yes, we are required to have 32 hours of additional training each year. We do more than 32 hours though, but that's the requirement, 32 hours.
And do you believe you're well supervised in your position?
Yes,
And do you believe back in June through, say, August of 2018 that you were well supervised?
yes,
Now, I believe we talked a little earlier about the process by which your investigation gets put into a report. So you told us that you enter it into a computer system piecemeal. Is that fair to say?
Yes.
How quickly after you obtain the information do you enter it into the computer?
Generally within 24 to 72 hours.
And if it does take as long as 72 hours, what would be some potential reasons for the delay?
I could be out in the field investigating. I could be at a kids talk. I could be at a hospital. I could be at court, something like that.
Okay, so you would just be too busy to put it into the computer system right away. Is that
Yeah.
fair to say? All right. Now, besides you, do other people rely on the accuracy of your investigative reports?
Yes.
Who relies on it?
Courts, foster care workers. I don't know who else.
Is it important that the reports be complete and accurate?
Yes.
Is it within the course of CPS's business to make recommendations or decisions concerning child protection and placement?
Could you repeat the question?
Yes, is it within CPS's business to make recommendations or decisions concerning child protection and placement?
I wouldn't necessarily say CPS makes the decision about placement. We make the decision whether or not to file a petition to remove a child from a harmful situation. That's what CPS does.
Do you make recommendations about where a safe place to be would be?
Yes.
Do you make recommendations about anything relating to a permanency plan?
But early on, no. That's not really CPS's realm. That would be more of a foster care worker's realm.
Okay. In 2018, well, strike that. You told us that CPS's preference is to place a child with a safe family member. Is that fair to say?
That's fair. Yes.
And if is a distinction made between a close, safe family member and a not so close family member?
Ms. Weingarten, could you explain what you mean by close?
Okay, so is it CPS's preference to put a child with a blood relative who's safe rather than a non-blood relative who is also safe?
CPS's preference is to place the child with a relative that is safe and appropriate. We generally like to place with blood relatives, but there have been times where we have to place with fictive kin, which is not a blood relative.
But the preference is a blood relative.
Correct.
Okay. Now, when you write your investigative reports, how long are they? How many pages?
It depends. It depends on how many social work contacts you have, how many people you've spoken with. That determines the length of the report.
Are there times on one case that you write more than one investigative report?
Are there times on one case where there is more than one investigative report?
Yeah.
I'm not exactly sure if I understand.
All right, well, let me see if I can phrase it differently. If there are 5 children in a family and they have different mothers or different fathers, and they're being removed from the home, do you write one large investigative report for all of them, or do you write separate reports?
You write one large report.
And are these reports single-spaced or double-spaced?
They're single-spaced.
When you file a petition, given the same hypothetical, if there are 5 children removed who have different mothers or fathers, how many different petitions are filed?
It depends on how many mothers there are. The petitions go in the mother's name.
Is the information in the investigative report duplicated into the petition?
Yes, some of the information, yes.
Have you been given some exhibits to discuss prior to today?
Yes,
Were you given something that has been marked exhibit number 4, a Child Protective Services investigation report?
yes.
Can you tell the judge how many pages long it is?
Well, we're now getting to a specific report related to the incident in question here.
But I'm not asking for the content. I'm asking for the length of it and whether it's single spaced or not.
Right, so you're asking in essence for part of the content, whether it's single spaced, that's part of the content.
And I
Your Honor, this runs afoul of the earlier ruling and also runs afoul of the fact that these are confidential reports, not subject to disclosure.
Judge, I don't think those questions get into the content of the report, and that I don't think that is confidential. And the Attorney General is on the Zoom call with us, and she's not objecting to that question.
Well, I'm certainly objecting to the question you're asking about the number of pages and whether this particular report is single spaced, etc. It's very specific to this report that is at issue in this particular matter.
All right, thank you. I think we should have a sidebar to discuss this a little further. So let's do that. Let me
Judge,
open up.
do you want the Attorney General to join us in the sidebar?
Mr. Ashcraft, I'll have your response. I do have a response for that. Do you have any objection to that?
Well, Judge, I think that the first issue is one that we should take care of with Your Honor as counsel for the parties in this particular case. Then, depending upon how Your Honor rules, it might have to be revisited with the Assistant Attorney General if something else needs to be done. But I would prefer that it just be counsel and Your Honor first.
Ms. Weingarten, do you have any objection to that? And we'll see
No.
where that goes. All right, so we'll go into the sidebar room along with the court reporter, and we'll have everyone else just remain out here in the hearing room. Take just a few seconds to get that done. All right, I think we are all back in the hearing room on the record. The objection is sustained. Please continue. Please move on, Ms. Weingarten.
Ms. Apple, do you have ways of determining whether child victims of physical or sexual abuse are coached by an adult?
No, I don't have a way. I kind of just go with my gut instinct, but no.
Are you forensically trained
Forensically trained how?
to interview children consistent with the Michigan Forensic Interview Protocol?
So I am trained in the forensic style protocol.
Okay, so is there anything about your training in the use of the protocol that helps you assess whether a child is being coached or not?
Not necessarily if a child is being coached, but in speaking with children, I do ask open-ended questions. That leaves space for open dialogue.
And what is the reason you use open-ended questions?
So that the child can speak freely.
Do you assess whether a child uses language that most children at their developmental stage does not use?
Yes.
Do you assess whether the story they tell sounds like it came from them rather than from an adult or someone else?
I assess what the child says. Children are very different, and some children speak are on a different level than other children. So it's not for me to make that decision. I just take what they say.
In the course of your career, have you ever had children tell you things that made you think they were being coached?
Yes.
And if you do have that belief, where do you document that somewhere?
Yes.
Where do you document it?
I will put it in my notes, and it will go in my social work contact. I generally state something like it should be noted, and then if I have an opinion, I'll put it then.
Does that opinion then get put into the investigative report?
Yes, it would be in my social work contact.
So I just want to make sure we're clear that the social work contacts go into your investigative report.
Yes.
All right, thank you. I have no other questions.
Thank you, Mr. Ashcraft.
Yes, Judge, thank you. Good afternoon, Ms. Apple.
Good afternoon.
testifying in court is a big part of your job as a CPS worker, correct?
Correct.
So on average, a CPS worker appears to testify in court how often?
How often in what time span are you
For
asking?
example, in the course of a week.
In the course of a week, maybe once, maybe not at all.
In the course of a month.
Maybe once a month, it depends.
And CPS workers are trained on how to effectively testify, right?
I believe so.
Is the training mandatory for all CPS workers?
Is what training mandatory for all CPS workers?
Is the training in terms of how to answer questions and appear in court and testify under oath, is that training required for all CPS workers?
I don't know if that's a specific training per se, but I can't answer that.
Thank you. One of the most critical parts of a CPS investigator's job is the placement of children who have been removed from their homes. Isn't that right?
Yes,
And before a foster care placement with strangers, Michigan law, as well as MDHHS policy, require that blood relatives be considered for placement, correct?
correct.
And first in priority, based on the law and MDHHS's policy, is consideration of non-custodial parents, right?
Correct.
Then blood relatives within a certain degree of blood, right?
Yes,
Then if necessary, foster or stranger care, correct?
correct.
So non-custodial parents are given preference over all other relatives unless they have been disqualified for consideration. Is that fair?
That's fair.
I want to talk for a few minutes about family team meetings. In your area of expertise, do you refer to those as FTMs?
Yes,
Are family team meetings another critical part of the CPS worker's job in arranging, coordinating, and participating in a family team meeting?
could you repeat the question?
Yes. Is family team meetings another critical part of the CPS worker's job, specifically your job to arrange, coordinate, and participate in those family team meetings?
Yes,
What is a family team meeting?
a family team meeting is a meeting where the CPS worker and invites the parents, and the parents invite support persons, and we sit around and dialogue the current allegations or the current concerns and come up with a plan on how to address them.
Thank you. So the specific purpose is to essentially triage the situation and do fact finding, correct?
The purpose of the FTM is to come up with a plan to resolve the matter at hand.
But in order to do that, there has to be some degree of fact finding, right?
It depends on what you mean as far as fact finding.
Investigating the matter to the point where you're able to go on to things like problem solving and decision making for the situation.
Not necessarily. I didn't mean to cut you off. Not necessarily. It depends on a case by case situation.
Understood. Problem solving is part of the family team meetings, though, yes?
That's true.
As well as decision making, correct?
Yes.
For example, like whether a child will be removed from the parent's home.
It depends on, again, it's a case by case situation. There have been instances where a child has been removed before this FTM has even taken place.
But ordinarily, it's a question to be considered is whether the child will be removed from the parent's home. That is something that is routinely discussed during family team meetings.
Correct.
And where and with whom the child might be placed.
Correct.
And is it the CPS worker's responsibility to uncover what, if any, services the family needs?
Yes,
and to assess the family's strengths and weaknesses?
yes.
Why is this important?
Be, because it's a team meeting. So it's a group of us coming together to figure out the best support for the child and the family as well. So it's not just CPS, it's a collective effort.
Thank you. And I want to ask you specifically about that. In terms of the collective effort, who participates in these meetings?
Again, the CPS worker, the family, and who else the family decides to invite. They can invite whoever they want as a support person.
How about professionals? Are any professionals present during these meetings?
Professionals are not present. Well, I take that back. Professionals like who?
Like a lawyer or a doctor or a social worker or a
No.
healthcare professional?
No, sir. It's just supportive persons.
One moment, Ms. Apple, when you say professionals are not present, do you mean they are not allowed or they generally are not present?
They generally are not present. Families generally do not have family team meetings and invite their doctor or a lawyer.
Thank you.
Okay, Your Honor, may I just have 30 seconds here?
Certainly.
Just to put on mute. Thank you.
That person there who said he reads lips. Who is that? Do you remember? Oh, that was the last time. The last time. He said it in. Mr. Ashcraft, yes.
Thank you, Judge. I needed to clarify something in my notes. May I continue?
Yes, I couldn't tell if you were trying to come back in or if you were needing more time. Are you ready?
Yes, I am. Thank you kindly.
Continue.
Ms. Apple, let me follow up on this to make sure I'm not missing something. When I say professionals, I'm going to broaden the scope of who I was asking about. For example, CPS worker's supervisor. Does he or she participate in family team meetings?
Yes.
And why is that significant?
It's our policy.
Does the supervisor make the one that makes the actual decision, for example, whether or not a child will be removed from the parent's home?
No, the circumstances actually make the decision whether or not a child will be removed from the home.
But is there someone who, at the end of the day, has to call the question and make that decision? Or is it simply a consensus amongst everyone who participates?
I wouldn't necessarily say it's a consensus amongst everyone that participates, because a parent is not going to say, hey, I want you to take my kid.
How about a facilitator? Does a facilitator participate in family team meetings?
A facilitator does exactly that. They facilitate. They don't take either side. They just document what's taking place.
I'm sorry, I may not have been clear. My question was, does a facilitator participate in family team meetings?
Yes.
Thank you. How are people notified or invited to participate?
It depends on when the meeting takes place. If it's an emergency FTM, it may be something as simple as a phone call. If there is time to notify folks, then phone call, a letter, things like that.
Assume for the sake of my next question that there is time to notify folks. Who is notified or invited to come?
You said who is notified?
Yes, ma'am.
The parent.
Objection asked and answered.
Any response before I rule?
Judge, it was an entirely different question following up on.
I will allow the follow-up. Go ahead.
Thank you. You may answer, Ms. Apple.
Could you repeat the question?
Yes. Who is notified or invited to come? And again, for the premise of that question, I asked you to kindly assume that there was time available that everyone who should be invited or notified would be able to be.
So that would be the worker, the supervisor, the FTM facilitator, and all parents of minor children.
Are parents allowed to have lawyers participate?
No,
Is it a goal to involve and engage the relatives as much as possible in the family team meetings?
if they're present,
And that would also include grandparents, yes?
if they're present.
Because they often have a great deal of insight into the family dynamics, the problems within the family, etc.
That's opinion-based.
I beg your pardon.
That's opinion-based. Not all grandparents are experts on their families.
I understand that, but my question was about having insight into family dynamics, problems, and the like. That's one of the reasons why it's good to have other family members present, such as grandparents, right?
I'm not going to agree with that because, again, all grandparents or invited participants may not have the best interest at heart.
Thank you. Involving them is usually in the child's best or the children's best interest, correct?
Involving participants that have the child's best interest at hand is generally the goal.
What about non-custodial parents who've not been involved with their children?
What about them?
Are they invited to participate? Are they notified?
They are notified if they're still legal parents, yes.
Do CPS workers such as yourself encounter that sort of scenario commonly?
Yes,
So CPS would need to verify any custody or parenting time orders regarding the children, correct?
CPS verifies whether or not the parent still has rights to that child.
In fact, CPS is required to do that. Is it true?
It's not a requirement.
Isn't it important to make sure that that's covered so your decisions don't conflict with potential court orders that are outstanding?
No,
Isn't that the case? So CPS can't take anybody's word for what custody and parenting time arrangements are?
that's why we searched court records.
And it would be against CPS's policy to place children in a home with a parent for whom the family court had ordered to have only supervised parenting time, right?
Repeat the question.
Yes. And it would be against CPS's policy to place children in a home with a parent for whom the family court had ordered to have only supervised parenting time, correct?
That's correct.
Especially because family members are often at odds over child custody. True?
It depends.
So CPS is required to verify these orders or the arrangements, correct?
Correct.
Are these parents notified?
Are which parents notified?
The ones that are subject to, for example, custody orders, visitation orders, and the like.
So all parents are notified.
Custodial and non-custodial.
Correct.
And there are rules or a protocol for the family team meeting. Isn't that right?
There are rules and guidelines, correct.
And what are some of those?
One person will speak at a time. There will be no disrespect during the meeting. If you have a question, raise your hand. Everybody gets a chance to talk, things like that.
One of the rules is no sidebar discussions are allowed among participants, right?
That's true.
So no whispering,
Is that sidebar?
no passing of notes,
Correct.
texting to other participants.
Correct.
And those rules are in place to avoid distractions, right?
Yes.
And to avoid the appearance of collusion or bias, correct?
Correct.
That's why the FTM coordinator is there, to be a neutral party, correct?
Correct.
And how are the rules conveyed to the participants?
At the beginning of the meeting, the rules are read. So before the meeting takes place, the rules are read and then an attendance sheet is circulated in the meeting. That way we'll have record of everybody who was there and that will also serve as record that they understand the rules of the meeting.
And everyone agrees in advance of the meeting to follow all the rules, correct?
Yes,
So the family team meeting is where the decision is made on how to proceed in a CPS case, right?
generally, yes.
What are the possible outcomes of a family team meeting?
It depends on the situation at hand, depends on the case.
A family team meeting is always convened when removal from the custodial parents or legal caregiver's home and foster care or relative placement is being contemplated, correct?
Not necessarily. You can have a family team meeting before you even get to that point.
When a petition to get the court involved is an anticipated outcome, right?
Yes,
Including petitions to terminate parental rights, correct?
correct.
And termination of parental rights would be sought in only the severest cases of abuse or neglect. Isn't that correct?
Correct.
Where there are serious safety or emotional or mental health concerns at issue. Yes?
Yes,
And some common bases for termination of parental rights are severe physical abuse or neglect, right?
correct.
A failure to address untreated mental health issues, right?
If it's detrimental to the child.
And it's against MDHHS's policy to place children in the care and home of someone alleged to suffer from untreated mental health diagnoses without investigating those allegations. Isn't that true?
Could you repeat the question?
Yes, ma'am. And it's against MDHHS's policy to place children in the care and home of someone alleged to suffer from untreated mental health diagnoses without investigating those allegations first, right?
It's unsafe for CPS to place a child in an unsafe situation without investigating the situation, period.
So would you consider someone alleged to suffer from untreated mental health diagnoses someone that could be an unsafe home situation for the child?
Yes,
So CPS can make a safety risk assessment, right?
yes,
Because the whole goal of CPS is to keep vulnerable children safe and healthy, correct?
correct.
And CPS cannot know whether children will be safe in that parent's care without first investigating credible allegations. Isn't that right?
Correct.
Multiple previous CPS investigations where the parent has not benefited from previous services, right?
What's the question?
In other words, that's something that needs to be investigated. The fact that there's been multiple previous CPS investigations where the parent has not benefited from those previous services.
Yes,
Also things like extensive violent criminal history, right?
yes,
That's necessary for a proper safety risk assessment, correct?
correct.
Abandonment for more than 90 days is another factor, correct?
Correct.
So it would violate CPS's policy to place children with a parent who has deserted her children for a minimum of 3 months with no contact and uninvestigated mental illness, correct?
Again, it depends on the case.
So it would be appropriate then sometimes to place children with a parent who had deserted her children for a minimum of 3 months with no contact and uninvestigated mental illness? Is that what you're saying?
No, what I'm saying is it depends. Those things may actually be true, but through investigation, there could be barriers as to why that parent deserted the child, or if that parent actually has mental health services, or if that parent is receiving treatment. So again, it's case by case.
Right, but the key though is the fact that there has to have been some degree of investigation to find that out.
Correct.
Thank you. Because that would place the children at risk of harm if that did not occur, right?
Correct.
And if there are allegations by family members that a parent is mentally ill and has a history of violent behavior toward others and the children at issue, CPS would have to investigate those allegations to ensure the health, safety, and welfare of those children, right?
Correct.
But if a prospective parent or caregiver does not cooperate with the investigation, say sign medical record release authorizations or maybe submit for mental health assessment, MDHHS's policy would prohibit the children from being placed with that person after removal from the home, right?
It again, sir, it depends.
So are you saying then that MDHHS would place a child with a parent or caregiver who does not cooperate with an investigation, does not sign medical record release authorizations or submit for mental health assessment when those things are at issue?
Again, sir, it depends.
But the decision as to how to proceed with the case is never made before the FTM is conducted, right?
No, that's not true either, because again, children can be removed from police at a home, and then your CPS is automatically writing a petition.
CPS is mandated to involve the family in the decision-making whenever that's possible, correct?
Yes.
Thank you. I'm going to move to a different area for a moment here. What are collateral contacts?
Collateral contacts would be speaking with a person who the family deems as someone that could be maybe supportive to them. Or even not even that, speaking to a police officer, a teacher, a doctor, that's a collateral contact.
So as part of a thorough CPS investigation, it's important to talk to any adult who has regular and extended contact with the family, right?
Correct.
And this, in fact, is required by CPS policy, yes?
Correct.
Because these non-relative adults can contradict or corroborate claims that have been made during the investigation itself, right?
That's true.
So in addition to relatives, that would also include teachers.
It would.
And by the way, teachers are mandated reporters of child abuse and neglect by Michigan law, are they not?
They are.
In fact, you would want to talk to any mandated reporters who are involved with the children and family, correct?
Correct.
Such as neighbors,
Correct.
godparents.
Correct.
If the children attend regularly attend activities such as daily or weekly sports, dance, choir, youth fellowship at church, CPS would need to interview those youth leaders. True?
They can. It's not mandatory.
Well, especially if one or more of the family members told the CPS investigator that those people could corroborate or contradict allegations that were then in dispute, right?
Again, not necessarily.
And if a parent or other family member told CPS that an adult who has extended a frequent exposure to the children and family heard on of the children in question, say his mother coached him to lie about material allegations in the investigation, CPS would be obligated to interview that person, correct?
CPS will be obligated to interview who?
That person,
Who is that person?
an adult who has extended or frequent exposure to the children,
Yes.
and that adult who has frequent and extended exposure to the children, and the family heard the children in question say that his mother coached him to lie about material allegations in the investigation. CPS would be obligated to interview that person, yes?
CPS is obligated to interview anybody that has information that's pertinent to the case.
Thank you. I want to ask you now some questions about Kids Talk forensic interviews. Another big part of your job as a CPS worker is arranging, coordinating, and participating in Kids Talk interviews, right?
Yes.
What is a Kids Talk interview?
It's an interview that takes place with a forensic interviewer. The child is recorded, and then they're asked about the current allegations or what's taking place, what's happening.
Sometimes CPS does a joint investigation with law enforcement, right?
Correct.
How is that determined?
If CPS does a joint investigation with law enforcement,
Yes, ma'am.
well, it depends on the allegations. For example, if you have a case with severe physical abuse, then and police are called out, child abuse unit would be assigned to the case. And so the child abuse detective would work with the CPS worker hand in hand investigating what took place. So an officer and a CPS worker may both sit and attend the Kids Talk interview.
But how would the labor be divided? In other words, who would serve as the investigation lead? The CPS worker?
So they're two different jobs. The CPS worker would lead the CPS investigation, and the police detective would lead the child abuse investigation.
Understood. How's information shared within that joint investigation?
What do you mean, how is information shared?
Well, for example, if both the police and CPS are involved in a joint investigation, are they exchanging information?
It depends. If both CPS and police are at the Kids Talk, then we're both there to hear the information together. And anything outside of that, we communicate via phone.
So is it fair to say, Ms. Apple, that a joint investigation really is, the objective is for it to be a team approach?
You could say that.
For joint investigations, if there is a Kids Talk forensic interview of a child, a representative from each agency, MDHHS or CPS, and the police attends or participates in that Kids Talk in some capacity, right?
Yes.
So all CPS specialists are trained in the protocol?
Trained in what protocol?
In the forensic interview protocol.
We are trained in the forensic style protocol.
Well, when you say forensic style, are you differentiating that from the forensic protocol itself? Is that something different?
That is something different. All CPS workers do not go to get specific forensic protocol training. That's something different. CPS workers are trained on how to interview using the forensic protocol style.
And let's talk about you for just a moment, please. Are you trained in the forensic interview protocol style? Or are you actually, have you ever been trained or certified in the forensic protocol itself?
No.
The purpose of the protocol is to extract truthful statements from children believed to have been abused or neglected about that abuse or neglect, right?
Correct.
So the Kids Talk interview is another investigative tool used in preparation for court in child protection or criminal proceedings, or both, in fact, right?
Correct.
And the interview can be described as hypotheses testing, not hypotheses confirming, right?
I don't understand.
Do you know the difference between hypothesis testing and hypothesis confirming?
No.
Is that something that you learned about during your instruction on the style of the protocol?
I said I didn't know what it was. I never said that I learned about it or I didn't learn about it.
And that's what I just didn't understand. I wanted to make sure that I understood what your answer was. And do you know what hypothesis testing is?
I said I didn't know what it was.
Same question. Do you know what hypothesis confirming is?
Again, I don't know what it is.
Understood. At the end of the day, you're looking for the truth, though.
Is that a question or a statement?
Yes, ma'am, that's a question.
Yes, I am.
Not confirmed preconceived conclusions, right?
Correct.
And the interview is also child-centered, right?
Correct.
What does that mean, child-centered?
Child-centered means the interviewer asks questions that the child can relate to at their age.
So that does not mean a CPS investigator would believe whatever the child says, no matter how outlandish, correct?
I don't understand what the interviewer and the CPS investigator believing an outlandish statement have to do with anything. What's the correlation? I'm confused.
I'm not asking you to draw a correlation. I'm asking you, it does not mean that a CPS investigator would believe whatever the child says, no matter how outlandish.
No, that doesn't necessarily mean that.
If the child made an outlandish claim in the kids' talk, like his father murdered someone in the house and got rid of the body, CPS wouldn't likely take that seriously.
CPS would investigate what the child said.
And a CPS investigator would not likely investigate a claim of his father beating him 500 times in one instance, which he knows because he counted, would it?
CPS investigator would investigate the injuries inflicted by being beaten.
CPS would be duty bound to document that claim, right?
Correct.
And the CPS would document such claims, correct?
CPS would.
And that's because the claims would tend to undermine a child's credibility, right?
You said it would intend to undermine a child's credibility.
Yes,
I'm not understanding what you mean by that.
because such outlandish claims, though investigated, would still tend to undermine a child's credibility. That's why they're investigated, right?
All claims, all allegations are investigated, regardless of how outlandish they sound.
A kids' talk interview is usually conducted at a facility or a center that is specifically designed for such interviews, correct?
Correct.
Usually there's only one person is in the room with the child, and that is the interviewer, correct?
Correct. Excuse me.
And that would be someone who is trained in the forensic protocol for the interviewing of children, right?
Correct.
And the other participants would be behind a one-way mirror or watching the interview on some separate camera system, correct?
In a different room, correct.
Intentionally out of view of the child who's being interviewed.
Correct.
And the purpose of that is to allow everyone who needs information from the child's interview to get it at the same time, right?
Correct.
So that the child won't need to be interviewed on multiple occasions by multiple people, right?
Correct.
And that's because multiple interviews of a child raise a high risk of influencing the child's statements. Isn't that right?
I don't necessarily know if that's true.
Because children are highly suggestible. You agree with that, right?
I can agree with that.
I beg your pardon.
I said I can agree with that.
Thank you. Especially if they are suffering trauma or emotional distress, right?
Yes.
And it's safe to say that all children interviewed at Kids Talk have been traumatized to some degree before their Kids Talk interview, right?
It's safe to say that, yes.
And only the professionals are allowed to participate.
Yes.
And only those who are involved in the investigation.
Yes.
So no non-professionals like parents or relatives are allowed to participate, right?
Correct.
And no professionals who are not trained would participate in any way.
I don't understand what you mean by trained.
Who are not specifically trained in the investigation protocol and the Kids Talk interview.
I can't agree with that because I haven't been trained in the forensic protocol yet. I participate in the actual Kids Talk, so I can't agree with that.
The things, okay, thank you. Everything that is done at the Kids Talk interview is governed by the protocol, correct?
Correct.
And how is compliance with the protocol rules monitored?
I'm not understanding the question. What do you mean?
Well, how is the Kids Talk interview monitored to assure that the protocol rules are being complied with?
That wouldn't be my area of expertise. That would be something for the Kids Talk reviewer to answer.
I'm sorry, you said the Kids Talk reviewer, and I'm not sure that I had heard that phrase before. Who's the Kids Talk reviewer?
The person that's conducting the interview at Kids Talk.
I understand. Thank you. Does that person have that as a title, meaning reviewer?
That interviewer, that's what maybe I misspoke, but the Kids Talk interviewer. I am not a Kids Talk interviewer, therefore I cannot speak to the rules and regulations and guidelines of Kids Talk.
I understand. Thank you. And do you know how compliance is enforced, if at all?
I'm unaware.
So you don't know if, for example, if the interviewer deviates from the protocol, another team member lets him know or her know right away?
I'm unaware.
Do you know whether there are some corrective measures that the interviewer should take in those instances?
I'm unaware.
Are the kids instructed not to discuss what they said with anyone not involved in a professional capacity with the Kids Talk? For example, parents or relatives?
Yes,
That's true.
yes,
During the interview, the children are not told not to discuss what they said in the interview with parents or relatives, right?
correct.
Mr. Ashcraft, back up and ask that question again. I thought I just heard two negatives, so I wasn't sure what the answer was. Ask the question, please.
During the interview, the children are not told not to discuss what they said in the interview with parents or relatives, correct?
You said they are not told not to discuss what
Right.
they talked about in their interview.
Correct.
So I don't know if I understand that question either. I know children are told not to discuss what was discussed in the interview.
With anyone?
It depends.
Are they instructed what they can and cannot say with regard to what was discussed at the interview?
I'm not aware.
No one tells the parents not to question or talk to the kids about the interviews, do they?
I'm not aware.
Okay, thank you. Your Honor, if I may have just simply 2 minutes to double check my notes, I believe I'm done.
All right, you're just going to go on mute.
If you don't mind, Judge.
Go ahead, that's fine.
Thank you.
Mr. Ashcraft, yes,
Thank you, Judge. May I proceed?
you may.
Thank you. Ms. Apple, just a few more questions for you. What are mandated petitions?
I don't know what a mandated petition is.
Is 90-day desertion considered severe neglect?
Yes,
And severe neglect requires the mandatory filing of a petition, correct?
not necessarily.
I have no further questions. Thank you.
Thank you. Redirect, if any, Ms. Weingarten.
Are you familiar with the term Child Advocacy Center?
Yes.
What is it?
The Child Advocacy Center was I believe it was a law group that, that there was a group of lawyers that I believe acted on behalf of the children.
Okay, so are you familiar with the Child Advocacy Center in Detroit that houses Kids Talk in an old Victorian house?
Yes,
Okay, the people who are the interviewers, are they police officers?
no,
Are they prosecutors?
no,
Are they protective services workers?
no,
Are they employees of Kids Talk?
yes,
And are they forensically trained to interview children?
yes.
Thank you. I have no other questions.
Mr. Ashcraft, anything further?
Thank you, Judge. I've concluded.
All right, thank you. May this witness be excused.
Yes.
All right, is this subject to rebuttal, or do you believe this, you're done with this witness?
Well, I think it depends on your ruling about the admissibility of certain investigative reports or petitions.
All right, I just asked the question because I'm excusing you for today, but not from the hearing. So the information with respect to sequestration and witness and hearing protocols are still in effect. Thank you.
Thank you.
All right, counsel, would you like to have a break before we call the next witness?
Yes, because I
10
have to
minutes.
call them and tell them to appear.
All right, is our 10 minutes sufficient then?
Yes.
There is one witness or one person in the waiting room, and that would be Mr. Fink. I don't see anyone else right now, but we'll take it's almost 3:40. Let's come back by 3:50, please. Thank you. Please remember to mute your microphone.
Thank you, Your Honor.
Council, are we ready to continue?
I am.
Ready to proceed, Your Honor.
All right, thank you. I see in the waiting room M.L. Eric and Herschel Fink, so I will admit them at this time.
I'm also expecting Keith Clark.
Ms. Weingarten, you did mention him before. Do you need to wait until he comes to start with this witness that your desire?
Or I could text him right now and tell him to get on.
All right, we'll wait a couple of minutes.
Well,
Meanwhile-
actually, I think he wants me to verbally say so during the hearing, and he's listening as he works. So I think
Oh, this is Mr. Fink. I was just talking to Mr. Elric, and I think he's watching. I think he's available.
is Mr. Elric on, John?
Mr. Elric is here. I see a face and I see the name, but you were talking about someone else.
Yes, Keith Clark. We can proceed without him, and I'll just verbally tell him he's listening to this. I'll
It
just
looks like-
verbally tell him to get on.
All right, it looks like he is here now. And he is coming in as an observer. He's not a witness.
Who are we talking about?
I'm Mr. Fink. I'm sorry.
All right. The other individual you mentioned was going to be an observer. That is,
That's me.
We have two observers.
yes. So Mr. Fink is one and the other one is, I believe, on his way in.
Well, he's got this on he's listening to it. So he wants me to verbally tell him to get on when I need his help playing the clip.
And he is now here on video also. He sees us, we see him.
Okay.
And his name is Keith Clark.
No, that's not who.
He-
I thought you were waiting for Michael Elric, ML Elric.
ML Elric is here, Mr. Fink. And so we've got you, we've got Mr. Elric, we've got Keith Clark, who is going to assist us with the video clip. And then we've got all the rest of the cast of characters.
That's correct.
Right word.
All right, thank you. So I'll ask everyone to mute themselves except for the players, and that would be Mr. Ashcraft and Ms. Weingarten, and then the witness that I will be calling. I believe that is M.L. Eric. Am I correct? Elric?
Elric, yes.
All right, thank you. So Mr. Clark and Mr. Fink, if you would mute yourselves, please.
Will do.
Thank you. Good afternoon, Mr. Elric.
Good afternoon. I should tell you, I had an audio problem. I just heard the last 30 seconds of whatever was said,
All right, are you able to hear me at this time?
loud and clear.
All right, if you don't hear a question that's being asked, would you please do something to let us know for sure that you're not hearing it? You can put your hand up to your ear, wave your hand, something, and we'll stop and make sure that the question is asked again. All right?
Sounds good.
We are going to start with me swearing you in. I am the appointed master appointed by the Michigan Supreme Court. Raise your right hand, please, to be sworn in. Do you swear or affirm that your testimony today will be the truth, the whole truth, and nothing but the truth, so help you?
I do.
Thank you. What is your name?
Michael Elric.
Thank you. And please spell that.
It's Michael. My last name is Elrick. I'm also known as ML Elric, which are just the initials M period L period.
All right, thank you. Mr. Elric, there were two orders in relation to this particular hearing, one having to do with sequestration of witnesses and the other one having to do with the hearing and witness protocol. Have you received or been given information with respect to those orders?
I did receive them. I reviewed both of them and I've complied with them.
All right, thank you. I'm going to go over the pertinent parts of them right now, and then I'll ask you again if you have abided by those and if you are swearing or affirming to continue to abide by those unless and until you are released from these orders. Sequestration order. This order and the sequestration will remain in effect until the witnesses are released from it by the master or until the proceedings before the master conclude. To be clear, this means that the order remains in effect even after the witness testifies unless the witness is released by the master. Sequestration includes a prohibition on any witness except while testifying via Zoom during the proceedings from doing any of the following: discussing his testimony in any format or by any means with another witness, viewing the proceedings on any device, listening to the proceedings on any device, or accessing or viewing any information about the proceedings via any social media or news outlets. Potential witnesses may discuss the pending formal complaint with counsel for the parties and may be shown exhibits by counsel prior to their testimony. It is the duty of counsel to, well, that one's not pertinent to you. Let me go to the next one. A failure to serve the order by any party or a violation of the order by a witness is grounds to exclude a witness or exclude testimony given by that witness prior to the discovery of the failure or violation. Any questions with respect to that order?
No, Your Honor.
All right, thank you. The order regarding hearing and witness protocol and pertinent part. Counsel shall ensure that all witnesses have hard copies of the exhibits required for their testimony. Do you have any copies of any exhibits that are required for your testimony today, sir?
I do not.
Do not have any exhibits. All right, thank you. If that comes up, we'll visit it a little further if that is necessary. Witnesses shall certify that they are alone in the room where they testify or identify all individuals present during an examination. Are you alone in that room?
I am. A dog might run in, but we can trust him.
All right, there are no other individuals in the room with you, and if someone does come in, you would let us know. All right, thank you. No witnesses shall access or review any documents or other materials beyond the relevant trial exhibits, pleadings, or transcripts or police reports during their testimony until the trial is over. No witness shall have a document within reach or sight. If a witness needs to refer to a document, he may do so only if invited by counsel to or approved by the master. Witnesses shall certify under oath that no one has given them information by any means to assist in testifying that counsel and the master cannot observe. Do you so certify, sir?
Yes, Your Honor.
Thank you. Witnesses shall not have access to cell phones, laptops, smartwatches, or similar devices in the room during their examination other than the device they will use for their virtual testimony. What device are you using for your testimony?
I'm using a desktop computer. I do have a smartphone, but I can put it in the hallway if you like.
All right, please do.
Okay, I'll be right back.
Thank you. Do you have any other questions regarding this order?
No, Your Honor.
All right, and do you swear or affirm that you have abided by these orders and that you will continue to abide by them unless and until you are released from the orders?
I do and I will.
Thank you very much. Counsel, are we ready to proceed with this witness?
Yes, but before we do, I would like to talk with Mr. Ashcraft for a minute. I thought we had a stipulation, but I'm not sure that he got back to me that it's final.
All right. Do you want just the two of you to be in a breakout room?
I don't know that that's necessary. It's not anything that you won't hear about. I just want to know from Mr. Ashcraft, can you stipulate that the thumb drive we sent you was the interview that Mr. Elric conducted and the story he aired?
Yes, and you're still only playing the 6 or 7 second clip.
Yes, yes.
Thank you. That is correct.
Okay, I'm ready, Your Honor.
All right, thank you. Let's proceed.
Tell the master your name, please.
Michael Elric, ML Elric.
How were you employed before December of this past year?
before December this past year, I was a reporter at the Detroit Free Press.
Before that, what was your job?
I was a reporter at Fox 2 News.
And what is your plan for the future?
I'm currently a candidate for Detroit City Council.
During your duties as a reporter, did you meet a person by the name of Tracy Green?
I did.
And do you see her here on this Zoom call?
I do.
Before you met with her, did you know her?
I did not know her.
Did you attend any of the court proceedings involving her son, Gary Davis Head Sr.?
I attended some of the criminal proceedings in Frank Murphy Hall of Justice. I did not attend any of the proceedings in the Lincoln Juvenile Court.
Did you do a story that aired on Fox 2 News about that case?
I did.
At some point, did you interview Judge Green about the case?
I interviewed Judge Green about some of the proceedings in the Lincoln Hall of Justice matter.
Do you know when it was that you first met with Ms. Green to interview her?
I believe it was in 2018. It was shortly before the stories were broadcast.
Can you tell us what procedure you went through before you created your story that aired? Did you meet with her personally?
Yes, I mean, I did some research. I contacted the judge. The judge put me in touch with her media representative. I spoke to the media representative. We set up a interview, an on-camera interview, and we conducted the interview.
So let me go back. When you say you contacted the judge, do you mean Judge Green?
Yes, Judge Green.
And when you talked with her, was she a judge at that point?
She was a judge in the juvenile court.
Are you sure she was not a family lawyer in the juvenile court?
No, when I spoke to the judge, she was serving. She had been elected, I believe, the year before, and had begun to hear cases.
Okay, so you set up an interview with her, and was anyone else present?
Yes, there was a photographer from Fox 2, John Brzezinski, and Darcy McConnell, who was Judge Green's consultant, media representative, was there as well.
In general, what does a media representative or consultant do?
Some people use them as spokespeople who speak on their behalf. Others use them to coordinate interviews or to provide information and handle some questions from the media. It really depends on the relationship between that media consultant, that spokesperson, communications professional, sometimes they call themselves, and their client. Basically, when I contact the subject or the potential subject of a story we're looking into, some people speak to us directly. Some people have someone speak to us in an intermediate way or throughout the process. In this case, I spoke both to Darcy and to Judge Green.
Where did you have a meeting with them both?
I did, and I would say Darcy was the facilitator of the on-camera interview that we had with Judge Green.
Did you do a pre-on-camera interview?
Not with Judge Green. With Darcy McConnell, we spoke about some matters in detail. I may have had a conversation with Judge Green saying that I wish to speak with her before she connected me with Darcy or after she connected me with Darcy. I've known Darcy for 20 years, so Darcy may have contacted me initially to say, hey, I heard you called the judge. What do you want to talk about? But I did speak with Darcy at length on multiple occasions, and I had at least 2 in-person meetings with the judge.
Were these 2 in-person meetings on camera?
The first meeting was on camera. The second subsequent meeting there was no photographer present. It was just myself, Darcy, the judge, and her husband.
All right, so when you first met with Darcy, were you?
Just a moment, Ms. Weingarten. Just clarify her husband, who you're talking about.
His first name is Andre.
I do.
I'm sorry, the judge's husband, Your
Thank
Honor.
you. Thank you. Continue.
When you first met with Darcy, were you under the impression that she was representing Miss Green as Judge Green's media consultant?
Yes, there was never any question that Darcy was speaking on behalf of and representing Judge Green.
Did you tell Darcy what you wanted to write about or ask Judge Green about in your interview with her?
Sure. Yeah, the reporting process is we have information, we have findings, and then we speak to all the parties involved to see whether or not there's additional information that we should factor into our reporting, and frankly, to see whether or not there is a story. We don't decide that we have a story that we'll publish until we've spoken to all parties or given all parties the opportunity to provide all the information that they think represents their position.
So did Judge Green agree to give an on-camera interview with you?
Yes, Judge Green met with us. Judge Green and Darcy chose the time and the place, and were very gracious in answering all of our questions.
Do you know when the interview took place that was on camera?
If you mean the exact date and time, I do not have that committed to memory, but if you have that and want to refresh my memory, I'm sure I'll be able to tell you whether it's right or not.
I'm not sure what the answer to that is. All right, was it sometime after she became a judge?
Yes, Judge Green, I believe it was within the first year after she took the bench, but she had just been elected in the previous election cycle and had been on the bench for less than 2 years.
Okay. So you interviewed her and there was a cameraman present?
Yes.
Have you seen the piece that aired on Fox 2 News that you created on this case?
I have not watched it recently, but certainly we watched it before we published it or broadcast it. I've watched it since then, and I stand by everything that we broadcast. No one has challenged the accuracy of it, to my knowledge, to this date.
Your Honor, Disciplinary Counsel's Exhibit number 7 is a thumb drive of the interview. And I think Mr. Ashcraft will agree to stipulate that that is a complete story that aired on Fox 2 News. Is that right, Mr. Ashcraft?
Yes.
Okay. I'm going to ask Mr. Clark to play the 6-minute clip. And Mr. Elric, when he's done, I'm going to ask you if the person speaking is Judge Tracy Green and whether the statement she made was in any way altered or spliced or anything like that.
Excuse me for one moment, please.
Yes.
Your Honor, I believe that Ms. Weingarten said 6-minute clip.
I meant 6 seconds.
All right, thank you very much.
I was going to ask you to clarify that because 6 seconds was in my mind and I wondered if I had misheard. All right, so we're ready to have that 6-second clip played now. Is that correct?
Yeah.
I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous.
So he
It
made
just
it up.
didn't happen.
Mr. Elric, is that Judge Green who was speaking?
It is.
And for the record, we have just played that video for Mr. Elric. Is that a complete and accurate and unaltered version of what she said?
We did not alter what the judge said, but we did have a lengthy interview. We did not use every moment of that interview, but those words were the words that were spoken to me by Judge Green when we sat down with her on camera. There's no deep fake here. We can't do that. We don't do that.
Okay. Did Tracy Green ever tell you that she put makeup on Gary Jr. one time to cover a handprint because his brother Russell was teasing him?
No, I have no recollection of that. If I had been told that, we would have included it in our report.
Why would you have included it in your report?
because it would have been, it would have explained why the makeup was put on the boy's face. Instead, the judge said she didn't put any makeup on the boy's face. So it would have been either something, a contradiction that we needed to present for viewers, or it would have been information that we had not been privy to based on the public record and based on our reporting.
After that story aired, did you have any other communication from Judge Green?
I had communication with Darcy McConnell. I did reach out to Judge Green to follow up. The judge and I may have had a brief phone conversation sometime subsequent to that report airing. But to my recollection, the only time we sat down, actually, to my recollection, we didn't sit down and speak after that.
Did either Darcy McConnell on behalf of Judge Green or Judge Green herself ask you to do a correction to the story?
No, in fact, I was told by Darcy McConnell that they thought my story was more fair and better represented the judge's position than a subsequent story published in the Detroit News.
Okay. Did you have any other contact with Judge Green besides what you've testified to today?
On repeated occasions, I would call Judge Green, send her a text, send her an email, or speak with someone in her office requesting comment from the judge on subsequent matters, from her transfer from Lincoln Hall of Justice to the Frank Murphy Hall of Justice, or on the proceedings involving her son when he was on trial for domestic violence and child abuse. But I do not recall the judge ever responding to me with a phone call. There may have been a cursory text or email saying something to the effect of no comment or thank you for reaching out to me. But other than our two face-to-face meetings, I believe all of our conversations were very brief and telephonic, with the occasional text or email of little consequence.
Your Honor, I don't think I have any other questions, but could I step down the hall for a moment and talk to Mr. Hellick?
Yes, you may. Do you want a 5-minute break?
Or less?
All right. Let's go on break for 5 minutes. We'll ask the witness to stay where you are and we'll be back, but you may put your microphone on mute and you may stop your video if you'd like. I think that we are all back. It looks like it. All right, Ms. Weingarten, you want to continue, please?
I have no other questions of this witness.
Thank you. Is there any cross-examination of this witness, Mr. Ashcraft?
Yes, Judge, thank you. May I proceed?
You may.
Good afternoon, Mr. Elric.
Good afternoon.
You've testified to several may-haves today, haven't you?
I believe so.
You testified to a number of no recollections this afternoon, haven't you?
I may have.
Mr. Elric, Tracy Green did not say that she did not put makeup on the boy's face, did she?
She said that she did not put
If you would
makeup.
kindly just answer my question, sir.
That is not correct.
Tracy Green did not say that she did not put makeup on the boy's face, did she?
Would you like to play the clip again, sir?
Yeah, let me just read it for you. Tracy Green actually said, quote, "I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous. It just didn't happen." Did I read that correctly?
I don't know what you're reading from. If you want to play the video, I'd be happy to compare the two.
Sure. If you don't want to acknowledge that what you said is inaccurate, then let's go ahead and do that. Ms. Weingarten, could you kindly have your technician replay the 6 seconds for us?
Yes, Mr. Clark, are you still on?
Yes, I am, and I'm going to play it right now.
Okay.
I didn't put makeup on any bruises to conceal any abuse. That is utterly preposterous.
So he
It
made
just
it up.
didn't happen.
Your recollection was incorrect, was it not?
What was my recollection, sir?
You testified, sir, that Tracy Green said that she did not put makeup on the boy's face. That's what you testified to.
She told me she did not put makeup on the boy's face.
That's not what was in the clip we just listened to. Do you agree?
She went further to say that she did not put makeup on the boy's face to cover up any bruises.
So you're saying that that's part of your interview, you just chose not to use it?
No, Judge Green.
No, I just asked if that's what you did. You chose not to use it? Is that what you're saying?
Can you restate the question?
No, I'll move on. Corey Bressler brought this story to you, didn't she?
No, she did not.
At some point, you became aware that Christine McDonald of the Detroit News was also working on the story, right?
I did.
And once you learned that, time became of the essence to break the story, did it not?
In the news business, when you have a story.
Excuse me, sir, did it not?
Would you restate the question?
Certainly. And once you learned that, time was of the essence to break the story, correct?
Incorrect.
You needed to beat Ms. McDonald in airing, didn't you?
That is not true.
But you didn't even know how far along she was with her story at that time, right?
That is true.
You were head to head with Ms. McDonald in competing on this story, weren't you?
That is not true.
In fact, you both published your stories on the same day, May 15, 2019, right?
I don't know that to be true. It may be true.
So that race to break the story was very tight, was it not?
It was not.
Mr. Elric, you only met with Tracy Green one time, correct?
That is absolutely and utterly untrue.
You told Judge Green's media consultant that you wanted an on-camera interview, did you not?
I did.
And you texted Judge Green about an interview too, didn't you?
Do you have that text? I believe it's true, but if you have that text, I'd like to see it.
You believe it's true?
I do believe it's true.
Thank you. But Judge Green wanted to talk to you on background to try to explain to you that the story didn't have any factual bases, didn't she?
We met on camera.
Excuse me. My question was, didn't she?
Would you say it again, sir? Because
Yes.
part of what you said, I believe, is untrue.
But Judge Green wanted to talk to you on background to try to convince you or explain to you that the story lacked factual bases, correct?
Judge Green wanted to meet to provide
Excuse
some
me.
additional
Excuse
information.
me. Is that correct?
That is incorrect.
What does on background mean, Mr. Elric?
I'll tell you what I told Judge Green.
Well, I would just like you to answer my question, sir. What does on background?
Your
mean?
Honor, he's not allowing Mr. Elric to answer the question.
The objection is overruled.
Thank you, Your Honor.
As I explained to Judge Green, on background means that you're providing information that we can use in our reporting to try and obtain additional information. You can provide context. You can suggest other avenues, but on background at Fox 2 does not allow us to use that information unless it's given to us from an official record, unless it's on the record with someone's name and likeness or voice, or if someone will attest to it. Judge Green declined to do any of those things, even though I asked her repeatedly to please provide us that information, have her husband say it for her, have a representative say it for her, or have her media representative say it for her. We discussed the terms of on background repeatedly. She declined to do anything.
Mr. Elric, you said you would only talk to Judge Green on background if she spoke to you on camera, didn't you?
That is not my recollection.
And you would decide later whether to use the video recorded interview, didn't you?
That is absolutely not true.
And you knew ahead of time that Judge Green couldn't say much on camera because of the judicial canon's prohibition against discussing pending cases with the media, didn't you?
That is not true.
Well, Mr. Elric, in the video that we just showed, just before and just after the segment that was aired, Judge Green specifically answers to one of your questions that she can't answer the question because she's prohibited from talking about the case because of the canons. Do you recall that?
Counsel, I recall
Excuse me.
30.
Excuse
I
me,
recall.
sir.
Excuse me. I
Do you
recall a
recall
30 to
that?
45-minute interview. That was
Move
not
to
a brief
strike,
exchange.
move to strike,
One
Your Honor. He's
moment.
not responding to my question.
One moment. This is cross-examination. Please answer yes or no. Let's continue. We'll strike that last interchange. Ask your question again, please, Mr.
Thank you.
Ashcroft. Craft.
Thank you, Your Honor. Thank you, Your Honor. Mr. Elric, do you not recall that during the interview, parts that weren't played for our master today, that Judge Green specifically, in response to some of your questions, indicated that she would like to give answers, but she could not because she was prohibited by the judicial canons from doing so because of a pending case. Do you recall that or not?
That's a different question. Do you want me to
Excuse
answer
me.
that one?
Do you recall that or not?
No.
So you took about 8 minutes getting Judge Green on film, right?
What do you mean we took 8 minutes getting her on film?
Do you recall how long your video interview was of Judge Green?
Yes.
Was about 8 minutes, was it not?
No.
But afterward, you spent 3 hours talking to Judge Green, didn't you?
I thought you said we only met together once.
Excuse me. Afterward, after the interview on film, you continued your dialogue for 3 hours, did you not?
No.
Who else was present this entire time when you met with Judge Green after the on-video interview?
The second meeting?
Do you understand my question?
I do not.
Mr. Elric, do you recall that you met with Judge Green on a day and that for 8 minutes and 19 seconds, you interviewed her on video? And then immediately after that, she stayed with you with someone else present, and you spent 3 hours talking about the story. Do you remember that?
There was a second meeting that lasted for 3 hours.
Who else was present the entire time of that meeting, as you describe as a second meeting?
The entire time, it was myself, Judge Green, Darcy McConnell, and Judge Green's husband was there for part of the time, but decided to leave because I understand that he was inebriated.
Is that right, Mr. Elric? That's what you understand?
That's what I had been told.
I see. Now, Darcy McConnell at the time was Judge Green's media consultant, correct?
She was.
During this 3-hour session, you took copious notes, did you not?
The second session,
During this 3-hour session, Mr. Elric, you took copious notes, did you not?
I'm going to need some clarification here because there were 2 sessions. One did not last 3 hours. One did last 3 hours. In one session, it was recorded by video. The second session, I met with the judge and took notes.
For 3 hours, right?
Yes, believe me, it was a long session.
And you took copious notes, didn't you?
I took notes during our meeting.
Can you answer my question, sir? We'll be done with this a lot swifter. You took copious notes during your 3-hour session with the judge, correct?
I think the issue here is your adjective copious. I took notes, whether they were copious or cursory, I can't speak to that.
Well, you're a professional journalist. Do you not take copious notes?
I take notes. There are times during an interview when people say, would you put your pencil down because I want to tell you something? And I respect their wishes. During our first meeting, I believe I took some notes while we recorded it. They were not copious. During the second meeting that you seem to question the existence of, I did take notes.
And you asked lots of questions during the 3-hour meeting, didn't you?
I asked follow-up
Could you
questions.
simply answer my question, sir? You asked a lot of questions during your 3-hour meeting with Judge Green, right?
I asked questions, whether it was a lot or a few.
Your Honor,
I do
I
not
would
recall.
I would object and ask that Your Honor instruct Mr. Elric to answer my questions.
Mr. Ashcraft, ask your question again. Mr. Elric, answer the question if you can with a yes or no. Continue.
Thank you, Your Honor. During your 3-hour meeting with Judge Green, you asked a lot of questions, correct?
I'm going to have to ask my counsel, Your Honor. There's not a yes or no answer to that question. I did take notes, whether there are a lot of questions or not. It's a very subjective thing, and that's not a yes or no question. I did take notes, whether it was a lot or a normal number.
Your Honor, my question wasn't even about notes. I'd moved on to whether he asked a lot of questions.
All right.
I asked questions. What can we define a lot? It was a 3-hour meeting.
Okay.
I did a lot of listening, if that's helpful.
So during your 3-hour meeting, you gave Judge Green the impression that you were really considering all of the counter narrative that she provided to you during that 3-hour session, right?
I listened to what Judge Green had to say, and I explained to her if she wished that to be included in our report,
right?
she would need to put it on the record, to have somebody else put it on the record. She declined to do so, sir.
Your Honor.
Mr. Elric, I don't know if you need to talk with your attorney or not, but right now on cross-examination, Mr. Ashcraft is asking for a yes or no, and then there will be an opportunity for redirect after that. Mr. Ashcraft, please ask your question again.
Thank you, Your Honor. Mr. Elric, during this 3-hour session with Judge Green, you gave her the impression that you were really considering all of the counter narrative information she provided to you, correct?
Yes.
Like her former daughter-in-law, Corey Bressler's history of violence and untreated mental illness, right?
I do not recall specifically what she presented to me.
Like her long vendetta against Tracy Green, whom she blames for losing custody of her children to Gary Davis had, right?
The judge did make that claim, yes.
Like her history of perjury, correct?
I do not recall that, no.
Like Ms. Bressler's history of CPS investigations, one where she struck Gary Jr., giving him a black eye and blaming it on Russell, his brother, correct?
No.
Like Ms. Bressler stalking Gary Davis had and another woman after he left her for that woman and had a baby with that woman, correct?
No.
She provided you a lot of information, did she not?
Mr. Elric, that was your laptop, is that correct?
No, my phone connects to my Macintosh, so I can decline a call. It's picking the call up from the other room, so I just declined it.
All right.
Would you please restate the question?
Yes, sir. Judge Green provided you a lot of information during your 3-hour session, correct?
No.
Okay. Much of it could have been independently verified. Isn't that right?
No.
But you didn't independently verify most of the information she provided with regard to on background, correct?
I'm sorry, you said I did not independently verify most of the information she provided?
That's correct. Is that right?
Would you restate that? Because I want to make sure I understand the question.
Sure, I'm happy to do so. You did not independently verify most of the information on background that Tracy Green provided to you, correct?
I could not verify information that didn't
Is that
exist.
correct or not correct, sir?
I think you're going to have to rephrase the question.
I'll move on, Mr. Elric.
If you want me to understand, you're going to have to rephrase it. I'm sorry. It's poorly worded, but
The reason that you did not independently verify most of the information on background that Judge Green provided to you was because you did not have time to verify that information because of the situation with Ms. McDonald and needing to beat her to the punch, right?
completely and utterly untrue.
But you knew that by omitting most of what Judge Green.
Your Honor, may I say something at this point?
One moment. I'm going to have us go into a breakout room for a sidebar with Ms. Jorgensen, because I want to know what it is you're going to say before you say it out. So let's take that break. We'll leave the witness here on the witness stand. All right, I think we are all back at this time. The objection is overruled. You may continue, Mr. Ashcraft.
Thank you, Your Honor. Mr. Elric, you knew that by omitting most of the on-background information that Judge Green provided you would mislead the viewers, didn't you?
Mr. Elric, please. All right.
Sorry, I'll say it louder the second time. That's untrue.
And that's a violation of journalistic canons, is it not?
What is?
Omitting information that's relevant and misleading the viewers.
To omit relevant information and mislead viewers would be a violation. I did not do that.
Thank you.
I did not do that, sir.
And the story that aired had scarcely any reference to what Judge Green told you in the 3-hour-long interview, did it?
Which interview, sir? The on-camera interview or the background meeting?
Well, you're saying, sir, that there were two, one that was a few minutes long and one that was 3 hours long. I specifically asked about the 3-hour-long one. Would you like me to state the question again?
I'd like you to stick to the facts. There was a long interview on
Excuse me,
camera.
sir. Would you like me to ask the question again?
Which question?
And the story that aired had scarcely any reference to what Judge Green told you in that 3-hour-long interview, right?
There was no 3-hour-long interview. There was a background meeting.
Is that right?
Your question has no basis in fact. How can I answer that?
So is the answer it's right or not right?
Let's pretend that you're right. Let's have the question again, if you don't mind, sir.
No, I think we just got the answer. I'll move on. So the truth is that you never intended to share any of the information Judge Green gave you during this 3-hour interview because those things did not fit the salacious narrative that you wanted to air, correct?
It was not an interview.
Is that correct?
Your assertion is utterly false.
Now Judge Green's son, Gary Davis, had lost parental rights to all 5 of his children and went to prison over the allegations you helped propagate in your story, right?
He was convicted of child abuse.
Is that right or not right?
Would you restate your question?
No. But Mr. Gary Davis Head is out of prison on an appeal bond now, correct?
I don't know that to be true.
And he's suing you and Fox 2 News for $10 million, right?
He has filed a lawsuit. I don't know if there's a dollar figure attached to it.
You're not aware of the amount of money that he's suing you and Fox 2 News for?
My understanding is in Michigan.
Excuse me, my question was, you're not aware of the amount?
I think I already answered your question.
When was that lawsuit filed?
I believe in 2020.
Give me for just 1 minute, please.
Certainly.
Now, I want to ask some questions before I move on in this area about your background. You've been a reporter for 30 years, correct?
Just short of 30 years.
And you've worked for just about every news outlet in Detroit, correct?
At least half of them.
The Detroit Free Press?
Yes, sir.
Where else?
I was a paper boy for the Detroit News. I worked for Channel 4. I worked for Fox 2. I've been a substitute host on WJR, and I have been a substitute host on Detroit Public Radio.
When you left the Free Press, You went to work for WJBK TV Fox 2 Detroit, correct?
I've left the Free Press many times, but in 2012, I left the Free Press to go work for Fox 2.
And you worked there for 7.5 years?
That's more or less right.
You left on December 17, 2019 on less than favorable terms, correct?
Objection
Incorrect.
relevance.
It's not true, but that's fine.
You essentially accused Fox 2 of delaying
One moment. Ms. Weingarten, you have an objection.
I objected to the relevance.
All right, Mr. Ashcraft?
Yes, Judge, I'm demonstrating bias connected specifically to the lawsuit that's been filed. I'll be able to connect the dots.
Ms. Weingarten, further objection at this time.
Is the lawsuit Mr. Ashcraft is referring to the libel suit that we've heard about?
Mr. Ashcraft, is it?
Yes, it is.
Your Honor, that was filed well after the story that was aired on Fox 2.
Thank you, Mr. Fink. Ms. Weingarten, any continuing objection?
No.
All right, objections overruled. Let's continue.
Thank you, Your Honor. You essentially accused Fox 2 of delaying the airing of a story you worked on that would have been negative publicity for one of Fox 2's biggest ad sponsors, right?
I objected to the delaying of the airing of a story.
Is that right, sir?
I did object, yes.
Your style is to report on sensational sorts of stories, correct?
No,
You report on scandals, do you not?
no,
You wrote the piece, The Kwame Sutra, Musings on Lust, Life, and Leadership, correct?
I did not write that. It's a compilation.
You participated in the writing, yes?
I did.
That was a play on words.
Your Honor,
Was it
another
not?
objection here. Mr. Elric won a Pulitzer Prize for his reporting on Kwame Kilpatrick. And after that, he and another reporter did this book that is a humorous book based upon some of the things that Kwame said in his text messages. It has nothing to do with this case.
Thank you.
Years before.
Thank you, Mr. Fink. Ms. Weingarten, do you have any objection at this point?
Well, if what Mr. Fink is saying, it happened years ago, I don't know how it's relevant to this proceeding. So I do object.
All right. The objection is to relevancy, Mr. Ashcraft.
Thank you, Judge. I'm demonstrating that Mr. Elric focuses on stories that involve scandal and sensationalism. And I submit that the report that was done on Judge Green and her family on May 15 of 2019 was one steeped in sensationalism and scandal. I'm doing
Your
so
Honor,
to demonstrate potential.
we're dealing with.
Excuse me, Mr. Fink, Mr. Fink, Mr. Fink, Mr. Fink.
Videotape.
Mr. Fink, I'm going to ask you to please mute yourself at this point. Thank you. Mr. Ashcraft, please finish, and I'm going to rule on the objection.
Thank you, Judge. The last part of my statement was simply, I'm exploring bias.
Judge, may I
Right.
respond?
I'm going to sustain the objection and ask you to move on. Thank you.
Understood. Thank you, Judge. Mr. Elric, you put a lot of time and effort into your investigations, do you not?
Yes, sir.
And you put a lot of effort into developing your story that Fox 2 aired on May 15, 2019 about Judge Green and her family, correct?
Yes, sir.
How long did you work on that? I mean, let me ask a better question. Was
Yeah,
it
I don't
weeks?
have a yes or no answer for that.
All right, so let me ask a better question then to help you out. Was it weeks,
No.
months,
Yes, sir.
years?
No.
You were aware that Corey Bressler, the mother of the boys you interviewed, was pitching the story about Gary Davis Head and Judge Green to multiple different news sources, correct?
Objection relevance.
Mr. Ashcraft, response.
The same connection, Judge, with regard to exploring bias.
All right, so I'm going to sustain the objection. And Mr. Ashcraft, if you would like to go on a separate record, we certainly may do that.
I need not do that at this time, Judge. Thank you.
All right, let's go.
Thank you. I'm going to go back to the subject of the lawsuit that we were talking about, Mr. Elric. Do you recall when it was filed, sir?
Objection relevant.
Response.
Judge, you already deemed that matter as being relevant for purposes of exploring bias.
To the objection of relevance for that specific question, I'm going to overrule the objection. And then I'm going to ask you to move on, Mr. Ashcraft, because I think we've covered this information. Continue.
Thank you, Judge.
I believe it was filed in 2020, but I don't recall specifically.
In fact, before the lawsuit was filed, Gary Davis had sent you a demand for retraction of your May 15, 2019 story about him and his family, correct?
Objection relevance. Judge, Gary Davis Head is not a party to this lawsuit. This is involving Judge Green. If Judge Green had asked for a retraction, that would be relevant and important to know.
Thank you. Mr. Ashcraft, any response?
Yes, Judge, it is relevant because it's the exact same story. The May 15, 2019 story involved Gary Davis Head as well as Judge Green in the exact same piece.
Thank you. The objection is sustained. Let's move on.
Thank you, Judge. Mr. Elric, you announced your candidacy on April 6, 2021 for what office, sir?
Detroit City Council, District 4.
And did you vow during your announcement of your candidacy to be transparent?
Objection relevance.
Any response before I rule?
Judge, it's my second to last question that goes to bias.
All right, I do not know exactly where the question is going, so I'm going to overrule the objection at this point. There might be another objection and I'll rule on it if I hear it. Go ahead, Mr. Ashcraft.
Thank you, Judge. The question was, when you announced your candidacy on April 6, 2021, you vowed to be transparent, correct?
I don't know if I use an exact term, but I vowed to be open and to answer questions, and I have nothing to hide.
But you were not transparent in the story you ran against Judge Green in May of 2019, were you?
I was transparent.
Your Honor, may I have just 2 minutes to review my notes and then I believe I'm done.
You may.
Thank you, Judge.
You're just going to mute yourself at this point.
If that's acceptable.
That is acceptable.
Thank you.
No.
Yes, Mr. Ashcraft.
Thank you, Judge. I have no further questions. Thank you, Mr. Elric.
Thank you. Anything on redirect, Ms. Weingart?
Yes. Mr. Elric, do you know how long the story was that aired on Fox 2 News?
On May 19th.
Yes,
This
Or
is
May
the
15th.
story. This
May
is the story that, sorry.
I believe it was May 15th of
Okay. Yeah.
2019.
Just to be clear, this was the story in which we interviewed Judge Green on camera.
Yes, as well as the boys.
6.5 minutes, 8.5 minutes. It depends. When we do a story, there's a thing called a package, which is the recorded story. And then there's some preliminary discussion with the anchor before and after. Altogether, I think it was somewhere between 6.5 to 8.5 minutes,
All right.
depending on how you want to measure.
You told us that there was a meeting with Judge Green on video, and then a 3-hour meeting, and then an airing of this 6 to 8 minute video. Can you tell us in what order of events those things happened?
Yes, we met with Judge Green at a time and place that was convenient to her. There were some preliminary conversations before we went on camera. We did a lengthy on-camera interview. After the interview concluded, Judge Green wanted to talk some more. We spoke some more. Then Judge Green left, and then I was left with her representative, and we had some more conversations. Subsequent to that, after I did more reporting, based on some of the material provided by the judge during the interview and some of the material provided by her representative, Judge Green asked if we could meet again on background. We discussed what the terms were of on background. Then the judge canceled the meeting. I said, well, we should still meet. You wanted to meet. I had to talk them into meeting. Then the judge and her husband showed up late. Then I stayed for 3 hours, perhaps more. The judge, her representative, her husband declined to put any of this information on the record or to provide documents that would allow us to include any of this information on the record. There were 2 meetings, one with photographer on camera, the other one without the photographer.
Was the third thing that happened was that the story aired?
Well, after the background meeting, it wasn't really an interview because we couldn't use any of the information if it wasn't going to be on the record or shored up with public records. There were subsequent discussions between myself and the judge's representatives. The judge and I may have spoken, I don't recall, but eventually we did do the story. Before the story aired, I did speak with the judge's representative, discussed what our findings were. There were no objections, no contradictions. The story was broadcast. That was that.
So you told her representative ahead of time what you were going to broadcast?
Counsel, every time I do a story, I speak to the subject of the story about our findings to give them a last chance to correct us if we misunderstood something, to provide any information that they may have chosen not to provide before for whatever reason. They chose not to correct anything, frankly, because everything was correct, and they provide us no more information. This is a standard thing where I give everybody a last chance to say whatever it is they feel they have to say, because that's only fair.
Thank you. I have no further questions.
Thank you, Mr. Ashcraft. Anything further?
Nothing further, Your Honor. Thank you.
All right, thank you. May this witness be excused.
Yes.
Thank you. You are excused, subject to any recall for rebuttal. The order for sequestration and hearing and witness protocol are still in effect. Thank you.
Have a good evening, everybody.
Thank you. You too.
All right. Are there additional witnesses today, Ms. Weingarten?
No.
All right, and we've talked about this before, Mr. Ashcraft and Ms. Weingarten. I believe you've indicated that you want to discuss something with me after we end today. Is that correct?
Yes.
All right. Is there anything further that needs to go on the record at this time, counsel?
Not that I'm aware of.
Not that I'm aware of either.
All right, thank you. So at this time, I will end the live feed. Let me just mention that our next date, and I will send you the link for that, but we've already determined that the next date is, I believe it's going to be on the 14th.
Correct.
And we start at what time, please?
I think you said 9:30.
9:30 is what is in the scheduling order. So unless we change that and do an amendment, it will be 9:30 on the 14th. At this time, I'm going to end the live feed. Is there any objection to that?
No.
All right.